Our guests have arrived. May I request the guests to take the positions on the stage, please, sir. Madhu, sir, please. A warm good morning to one and all. Thank you so much. Please be seated. All the audience, please be seated. I'm Dr. Anuja, Associate Professor from Manipal Law School, and I'm highly delighted to be the master of the ceremony for this event. It's indeed a momentous occasion at Manipal Law School, commemorating the 50th anniversary of the Keshavananda Bharathi versus Union of India, the landmark Supreme Court judgment, the fundamental rights case as it is known as. And today the day becomes much more auspicious with the representatives from judiciary, representatives from academia, and representatives from the spiritual community joining us to commemorate this special occasion at MLS. And that's where we have come up with the Constitutional Law Lecture Series 3rd edition program on constitutional ethos in the light of Keshavananda Bharathi's case. With this introduction, may I take a little bit of time to thank our guest, Judge Shri Indresh, Judge High Court of Karnataka. Thank you so much, sir, for taking out time for us within a short time and being here with us. Thank you so much, Professor. Thank you so much, Swamiji. Our humble pranams. Thank you so much for making it us, for sharing these momentous occasions. Thank you so much, Professor Madhu Veeraraghavan, who has always been there with us as a constant pillar of support and guidance. Thank you so much, sir. Thank you so much, Professor Avinash, whose brainchild the whole event is all about, and whom we always bang upon with regard to any of our obstacles and hurdles that we face. Thank you so much. With this stellar constellation of guests on the stage, may I welcome all the students and all the faculty across various colleges and universities within the state of Karnataka who have assembled here, who have joined us to commemorate this 50th anniversary of Keshavananda Bharathi decision. Thank you so much for your wonderful presence over here, and definitely it is going to be an insightful session that we will be having for the day. Thank you so much for the special dignitaries on and off the dais. With this introduction, we should go in for the Shubharamb. So let's have the lighting the lamp ceremony. May I request the guests on the
Janani Saraswati Palaya Mam, Janani Saraswati Palaya Mam, Amale Kamala Sana Sahite, Amale Kamala Sana Sahite, Adbhuta Charite Palaya Mam, Adbhuta Charite Palaya Mam, Chaturmukha Bharye Mam Pahi, Chaturmukha Bharye Mam Pahi, Vani Saraswati Vagdevi, Vani Saraswati Jaya Jaya Devi Dayala Hari, Jaya Jaya Devi Dayala Hari, Dayala Hari, Dayala Hari.
Thank you so much, Adv.Vanitha, for the soulful rendition of this prayer song. Now we have a small video with us regarding the life and mission of Keshavananda Bharathi Swamiji. Swamiji was an Indian Hindu monk who served as Shankaracharya. He is called as the head of the Edneer Mutt, a Hindu monastery in Kasaragod district, Kerala, India from 1961 until his death in the year 2020. He was the petitioner, he was the pioneer in the Keshwananda Bharathi versus State of Kerala, the one who brought in the case which outlined the basic structure doctrine of the Constitution of India. This landmark case helped establish the basic structure doctrine of the Indian Constitution, which guarantees that the fundamental or basic structure of the Indian Constitution cannot be altered by the parliamentary amendment. Swamiji was a follower of Smarta Bhagavata tradition and the Advaita Vedanta school of Hindu philosophy. So let's watch this small video which is in Kannada, and this is coming out for you. Please. Please, Sushant. Thank you so much, Sushant. Edneer Mutt is very famous as a center for cultural excellence, and surprisingly and interestingly, Keshwananda Bharati Swamiji had sung this song. He is the one who has done the rendition of this song. Thank you so much, Sushant, for playing the video for us. As we gather here, we are embarking on the journey to stimulate our knowledge, coming up with insightful dialogues, thought-provoking perspectives, and invaluable learning. I call upon Dr. Rahul Mishra to introduce the program to the audience.
Thank you, Dr. Anuja. My heartfelt pranam to revered Swamiji Shri Sachidananda Bharathi, Pontiff Edneer, Kerala, and my heartfelt greetings to all dignitaries on the dais, principals, vice principals, HODs, HOIs, faculty members, and dear participants. With the series program, let me just give you some understanding as to how the first two editions were done. So the very first edition of this program was done on November 26, 2022. At that point of time, Justice Shri Pinaki Chandra Ghosh, retired Judge Supreme Court of India, and Justice Arun from Karnataka High Court had basically graced the occasion, and very nice deliberations did happen with regard to Article 21, Article 14, Article 19 of the Constitution of India with regard to the issues concerning our society. When it comes to the second edition of this program, it was organized on March 17th, 2023, and wherein Justice Swatantra Kumar, former Judge Supreme Court of India and Chairperson of National Green Tribunal, along with Professor Dr. C. Basvaraju, Vice Chancellor, Karnataka State Law University, did grace the occasion. So this lecture series was basically a part of series of lectures to celebrate the significance of the Constitution at a time when there is a trepidation that the constitutional morality is being challenged within the domain of judicial interpretation of some recent contemporary issues. As we all know, there is an increasing anxiety among scholars that the idea of social justice apparent in the constitutional provisions is being diluted. Therefore, Manipal Law School has taken a lead in organizing and offering a platform to a scholaristic approach for studying Constitution by inviting legal luminaries on the dais of the dais, thereby having conducive deliberations. Therefore, I do believe that the third edition of Constitutional Law Lecture Series, which specifically celebrates the 50th anniversary of Keshwananda Bharati's case, shall give us very decisive insights about constitutional domains to be cherished for times to come. Thank you all.
Thank you so much, Dr. Rahul Mishra. I call upon Dr. Apurvi Srivastava, Associate Professor at Manipal Law School. Apurvi, are you here? I invite Dr. Apurvi Srivastava to introduce Professor Dr. Avinash Dadhich to the audience. Professor Dr. Avinash Dadhich is the Director for Manipal Law School. Please, Apurvi.
Apologies from my end, very sorry, and welcome everyone. It's my privilege to introduce Professor Dr. Avinash Dadhich to the august gathering. Professor Avinash Dadhich has a rich academic and industry experience with specialization in competition law, regulation of AI, robotics, governance, data privacy. He has completed his PhD from UK and LLM from France on full scholarship and earned LLB from University of Delhi. He was a visiting scholar at King's College London, Max Planck Institute of IP, Germany, and Institute of European Studies, Belgium, NLU Delhi, to name a few. He was also invited as Antitrust Fellow by Department of States, USA, under International Visitor Leadership Program to visit New York, Washington, DC. He completed Military Leadership Development Program as Officer Cadet at Wales University's Officers Training Corporation, British Territorial Army, UK. Professor Dadhich has attended and presented various research papers at international conferences, at International Governance Forum, to name a few, at University of Luxembourg, Paris, Oxford University, University of Amsterdam, European Commission, Brazil, Tilsburg University, and at WIPO, Geneva, Switzerland. We are really honored to have Professor Dadhich as our leader here at MLS. Thank you so much for being the guiding beacon for all of us. And now I welcome him to address the gathering. So please.
Om. Respected dignitaries on dais, Justice Indresh, Professor Rahul, Professor Madhu, and respected Swamiji, and my dear students, faculties, and colleagues from profession. The idea which we developed, that how to design a good constitutional law lecture series last year, and Professor Rahul took this initiative, and we are developing this idea this year also. So I must say, I think the credit must go to our sir. He gave this idea that let's do something in Keshwan and Bharathi case. Why Keshwan and Bharathi case? 1973, 50 years. It's a long time. Why still we are talking about a 50-year-old case in India? Because the time has come where people are questioning the verdict of this case. There is a debate in democracy, and I think that's the purpose of democracy. The debate is, should we have any control on the elected government, or should there be any boundaries for the elected government? At least in India, this debate is not new. Maybe in developed countries like in Europe, it was very clear that king cannot do any wrong. They accepted it, but not in our country. Historically, philosophically, spiritually, we all agreed that king can do wrong. And who will decide what is right and wrong? Dharma. Dharma will decide what is wrong, and the spiritual, philosophical people, they will tell the king that what is right, what is wrong. You can see hundreds of stories in our mythologies and historical documents where spiritual and philosopher people, they raised their concern, they objected king's ideas and king's decision in the public forum, not in private meeting, but in public forum. And interestingly, that was their job. It was their job to control the king's behavior and to regulate the society's behavior. So in India, I think we should not be surprised when a great saint, Keshwanand Bharati ji, Swami Keshwanand Bharati ji, he raised this issue before the Supreme Court, and the Honorable Supreme Court took a decision. So now the question arises that, okay, historically Dharma used to control, and Dharma, obviously Vedic Dharma, Manusmriti, and a lot of intellectual philosophical text used to regulate the behavior of the king. Now what about in a secular country? Because we have decided in our constitution that it's a secular country, so definitely we cannot be governed by religious text anymore, and it should not be. They can be guiding factor, yes, we should learn from them. We should learn from all dharmas. I think that's the beauty of Vedic philosophy, that we should learn from everything, everyone. The wisdom in India, anyone outside. If something is good outside, we should take it. And we should challenge it. But now the question arises that who will govern? What is the dharma? So the modern context, the dharma, in my understanding, is based on the liberal ideas which we developed in last 300 years. And those liberal ideas are nothing but rule of law, democracy, and how to govern a society in a fair manner. Separation of power. Definitely those ideas were not developed in India. I think we should give credit to Westerners for that, especially European and American philosophers. In 15th and 16th and 17th and 18th century, they developed these ideas like the French equality, fraternity. But why only it worked in India? That's an interesting question. In the post-colonization, decolonization process after 1945, when entire world went become free. They created constitutions, beautiful constitutions. But it didn't work. Did it work in China? No. Did it work in South America? No. Africa? No. East Asia? No. It only worked in India. Did it work in Pakistan? No. It only worked in India. Constitution worked in India not because that, okay, we had a constitution. Constitution worked in India because Indian mind believes in the constitutional values. You don't need to explain to a Vedanti philosopher or a follower or any normal Indian or a Hindu or any other religious people a concept about equality. You don't need to explain. We all believe that we are all same. There is no difference. We all come from the same Burma and we are the same people. Do you need to tell any Indian how to respect and protect environment? No. We all worship rivers. We have beautiful poems. Adi Shankaracharya, he wrote beautiful text on the praising the rivers, mountains. It's in our culture. So the constitution cannot work without the cultural framework. And the Indian cultural mindset was very much adaptive to the modern way of constitution. So I think we must appreciate that it's working because we believe in these things. So the Keshwanand Bharati case was a very big milestone in Indian constitution as well as in democratic system, where the Supreme Court said, yes, there has to be some boundaries. Whether you are an elected government, it's fine, but you are not, it's not UK where king cannot do any wrong. It's a India where king can do wrong. And who will decide? We will decide. It's a duty of the Supreme Court to decide how to control. And how we will control? Through the liberal ideas, through the democracy, through the separation of power, the supremacy of the judiciary. So my dear friends, I think that was a historical judgment. Maybe today you realize or not, but today you are living in a democratic world, in democratic India, just because of this judgment. Sometimes we don't realize, the historical movements happened and the people forget. Okay? We adopted a constitution in 1950, that was a big historical movement, but in 1973, the Supreme Court affirmed that yes, there is to be supremacy of the constitutionalism, not the constitution. You can change the constitution, we have no problem. But you cannot change the constitutionalism, the spirit of the constitution. I think that was the moment which gave the right to live in a democratic country. So we need to be very careful in future also that any government, any organization, any institution, including Supreme Court, okay, no authority, no person, no organization is supreme than the constitutionalism. So as a citizen of this country, as a teacher, student of the law, we are all students of law in this room. Okay, whether you're a student, a lawyer, or a professor, or a judge, you are all students of law, and it's our fundamental duty to protect the constitutionalism from everyone. Okay, because people need more power. They want more power. It's good. They should have power, but for the interest of the people, to protect the constitutionalism. So I think this debate and discussion which we will have today, we will talk about this relevance of this particular judgment in past, present, and future. So I think with these words I will stop, and I really thank to all dignitaries, Swamiji especially. I think this is only in India where the spiritual people, they always guided Indian society from Vedanta. If you see Chanakya, 2500 back, when a spiritual guru and a professor, Chanakya was not only a spiritual guru, but he was a professor too. So I think it's a great beginning in the MLS in MAHE Bengaluru campus that we are going to have holistic discussions and debates about the constitutionalism, rule of law, and the governance of the society in coming years. Thank you very much.
It is said that every day holds the possibility of a miracle, and exactly the same with the case of a constitution. And so the Constitution of India holds the possibility of the miracle, which got reflected in the wonderful landmark judgment, Keshavananda Bharati versus Union of India, wherein the democracy is upheld and the basic structure doctrine is upheld. Thank you so much, sir, for the insights provided. Aditi Devo Bhava at Manipal Law School, and this is the time wherein we are honoring our guest. Honorable Shri A.S. Bopanna, Judge, Supreme Court of Judge, had consented to be there. He was about to join with us, but unfortunately, because of personal exigencies, he couldn't join us. But in absentia, we acknowledge your presence, your blessings, and we look forward to you and your guidance with regard to the functions and activities at Manipal Law School. Thank you so much, sir. Now it's my proud privilege on behalf of Manipal Law School to present the memento through our dignitaries on the dais. May I request Professor Dr. Madhu Veeraraghavan and Professor Avinash also to join to present the memento to Shri E.S. Indresh, Judge, High Court of Karnataka, Bengaluru. Campus to present this floral bouquet to our guest. We have with us today Professor Dr. Srikrishna Deva, Vice Chancellor of NALSAR University of Law, a legal educator and administrator par excellence. Thank you so much, sir, for being here with us and joining us on this occasion. I call upon Dr. Rahul and Dr. Nagendra to present the memento to Professor Srikrishna Deva. Just be watchful. I call upon Ms. Revati to join me to present a floral bouquet to Professor Srikrishna Deva. It's my proud privilege with humble pranams. We are presenting this memento to Sri Sachidananda Bharathi Swamiji, who is a successor to the Keshavananda Bharati Swamiji. May I request Advocate Vasant Krishna and Advocate Vanitha VK to join us to present the memento to the Swamiji. Thank you so much, Swamiji, for being with us. A humble pranam. Thank you, sir. Thank you, madam. I call upon Dr. Sahana and Dr. Manjunath to present the memento to our Pro-Vice Chancellor, Professor Dr. Madhu Veeraraghavan. Thank you so much, sir, for making it us, along with us for the day on this momentous occasion. It's our privilege, sir. Thank you. I call upon Ms. Harkiran and Dr. Ella to join us for presenting the floral bouquet to Professor Madhu Veeraraghavan. Thank you, sir. Thank you, Harkiran, and thank you, Dr. Ella. Thank you, Advocate Vasant Krishna, sir, for always being with us in guiding us to navigate this process very easily. It is time to present the memento to Advocate Vasant Krishna, the Legal Counsel, Manipal Group. May I request Professor Dr. Raghavendra Prabhu to do the honors. Please, sir. It's our pleasure and privilege, sir. Thank you so much for being with us. I call upon Professor Sunil John and Dr. Grace to present the floral bouquet to Advocate Vasant Krishna. Thank you so much. I call upon Ms. Harkiran now to introduce Professor Dr. Madhu Veeraraghavan, Pro Vice Chancellor, MAHE Bengaluru campus, to the audience. Please, Harkiran.
Thank you so much for this opportunity. I take this opportunity to introduce Professor Madhu Veeraraghavan, who is the Pro Vice Chancellor of Management, Law, Humanities and Social Sciences, MAHE Manipal, MAHE Bengaluru campus from April 1, 2023. He also holds the position of TA Pai Chair Professor of Finance at TA Pai Management Institute, TAPME, and Dr. TMA Pai Endowment Chair in Management Research. He held the position of Director of TAPME from 2017 to 2023. Professor Madhu Veeraraghavan holds an MBA in Finance and Investments and a PhD in Finance. With over 20 years of experience in world-class and business schools, he believes that business schools should work for outcomes that support the mission of the school. Professor Veeraraghavan's research interests are in the areas of corporate finance, behavioral finance, and the interplay between auditing and finance. He is a referee for several leading accounting and finance journals. Professor Veeraraghavan has published over 50 papers in international journals and has presented his work in top conferences in finance and accounting. His work has appeared in elite journals such as The Accounting Review, Journal of Financial Economics, Contemporary Accounting Research, Journal of Financial and Quantitative Analysis, Journal of Corporate Finance, Journal of Empirical Finance, Journal of Banking and Finance, Journal of Management, Journal of Business Ethics and Auditing, a Journal of Practice and Theory. He is also revising manuscripts for Management Science, Journal of Corporate Finance, Journal of Banking and Finance, and the Journal of Empirical Finance. Professor Veeraraghavan has obtained research funding of over 500,000 Australian dollars from the Australian Research Council Discovery Grant Scheme and the Australian Research Council Linkage Grant Scheme. Professor Veeraraghavan has won many awards for his work in both national and international conferences. Recently, he has been ranked 180 in the world in the Brigham University 2022 Accounting Research Rankings for his contributions to accounting research. He is also a recipient of AICTE Dr. Preetham Singh Best Teacher Award 2021, awarded by the Honorable Minister of Education, Government of India. The Social Science Research Network, SSRN, has announced that Professor Veeraraghavan is ranked in the top 10% of the authors around the world. Professor Veeraraghavan is a trustee of Mitra's Foundation, an NGO that provides free skill development courses to participants from rural backgrounds with the sole aim of empowering young lives. Thank you so much, sir, for joining us.
Good morning to all of you. First, I would like to thank Honorable Shri Justice A.S. Bopanna, who was not able to be here in person, but we do carry his best wishes and blessings. Justice Indresh, sitting High Court Judge, High Court of Karnataka, respected Swamiji, the Vice Chancellor of NALSAR, It's just a great feeling to be here. I'm not a professor of law, as was just introduced. I'm a professor of finance. But I also take great interest in the sort of activities that MLS is running today under the leadership of Avinash and the entire faculty team. It is actually more heartening for me to see not just the MLS students, but students from, I think, 20 plus colleges around the state. And the reason we are doing this is, I was talking to Justice Indresh and he told me in the morning that for the first time in 4 years, he's actually taken off and he's come here. So can you imagine, with such a busy schedule, the Justice is here. And I think the real beneficiary of events such as this, Avinash and everybody else, are actually the law students. I'm not a law student. I'm not a lawyer or a professor of law by training, but I certainly think these sorts of even open you up to some of the most eminent discussions that we're going to have. Nobody is saying to you today the governments are not important. I don't think anybody will say they're not important. They certainly are important. The question that I've always asked myself is, how much power should a government have? Is it unlimited? Should it be arbitrary? Should it be unending, that the government can do whatever it wants? And I'm not talking about a certain government. I'm just generally posing this question to the law students and, of course, the jurists and judges who are here today. So that is an important discussion for us to have. The Kishwaran Bharati ji's case, as Avinash mentioned, and Rahul also and others, it's almost a 1973 case. So why is it relevant today? And when I first saw Avinash mentioning to me a week ago, or a couple of weeks ago, that we're going to do this, in fact, today is the convocation at Manipal, MAHE Manipal. And he said, you're not going anywhere, you're going to be here. I said, absolutely, I will be here, because this is a very, very important discussion we're going to have. And whilst it was decided on a 7-6 majority by, I think, the largest bench of the Supreme Court, it may have been decided before many of us were born. But the validity of that still exists today. So that's why I asked the first question. If the Parliament of the day has the power to alter the Constitution, perhaps it does, to what extent can it alter? To what extent can it amend? Can it amend to an extent where it sort of destroys the very fabric or the very basic doctrine structure of the Constitution? Can it amend to an extent where it doesn't destroy the doctrine, the structure, but to a large extent it can? I think these are very difficult questions to answer. The Constitution, as I understand, is a living document. It has life in it. And the life in it of the document is so necessary that all of us Indians, Avinash spoke about Dharma through the Vedic text. I don't dispute any of it. But if one were to uphold today as what is that sacred text that governs all Indians, that would be the Constitution of India. And at no point in time we must allow that to be violated. So therefore that is sacrosanct, that is almost set in stone. So today's discussion, and we have an eminent justice here who is going to talk about it. And I had the pleasure of browsing through Justice Bopanna's talk, which runs into 19 pages. And I'm hoping, Avinash, you would circulate Justice Bopanna's talk to the students. Fantastic. And I would like you to listen to it with rapt attention and absolutely keep your ears totally open, because when you hear what Justice Bopanna has drafted, you'll be just blown away by and that is why we have Justice Indresh here, we have Justice Bopanna's talk here, and this is such a momentous occasion for MLS and for MAHE Bengaluru that we have a High Court judge who is actually here to talk to you. So I don't want to stand between you and the most amazing justice who is going to give his view and his talk. I think you should listen to all of that, and perhaps we may have an opportunity, Justice, to have a Q&A session maybe later or today. I don't know when time permits. But I'm delighted to be here to welcome all of you to MAHE Bengaluru. I would like to congratulate Avinash and the entire law school, and Vasant Krishna, who's played an incredibly important role, the MEMG Council, in bringing together a set of luminaries on the dais. So could you please join me in welcoming and thanking all of them for putting together this great show. And also to all of you students who come from different parts of the state, of the city. I hope this day is very memorable for you and that you're able to draw upon some very important conversations that we're going to have, and perhaps serves you more as an inspiration. And maybe, you will take this profession much more seriously and perhaps go to the court and argue, and all of those things will happen. So thank you very much for being here, and I'm delighted that I'm able to listen to the Justice today and his talk, and also will have the pleasure of reading Justice Bopanna's scripted talk as well. So thank you so much.
Thank you so much, sir, for the encouraging words and the stimulus that you have given us for the day. Honorable Shri A.S. Bopanna, Judge, Supreme Court of India, has sent the keynote address as a message to us. So I would like to invite Dr. Rahul Mishra, Associate Professor at Manipal Law School, to read it out to all of us. And let's all, in absentia, acknowledge the presence of Shri A.S. Bopanna over here. Please, Dr. Rahul.
Constitution is not a mere lawyer's document, it's a vehicle of life, and its spirit is always the spirit of age, as said Dr. B.R. Ambedkar. Addressing dignitaries, members of the bar, ladies and gentlemen, I am honored to stand before you to speak at the third edition of Constitutional Law Lecture Series on the topic Constitutional Ethos in the light of the Keshwananda Bharati's judgment. Celebrate and discuss the landmark legal decision that has had a profound impact on the constitutional landscape of India. Today we celebrate the 50th anniversary of this historic ruling, delivered by the largest bench constituted at the Supreme Court till date, comprising of 13 honorable judges. On April 24, 1973, the bench comprised of Chief Justice S.M. Sikri, Justice J.M. Shalit, Justice K.S. Hegde, Justice A.N. Grover, Justices A.N. Ray, Justice P. Jagmohan Reddy, Justice D.G. Pallekar, Justice H.R. Khanna, Justice K.K. Matthew, Justice M.H. Beg, Justice S.N. Dwivedi, Justice A.K. Mukherjee, and Justice Y.V. Chandrachud, as they then were, within bracket. Constitutionalism. Before we discuss the judgment rendered in Keshwananda Bharati in depth, let us first talk about the doctrine of constitutionalism. Constitutionalism, as an idea, acknowledges the necessity of government, but insists on limits its authority. Constitutionalism's primary tenet is limited powers of the government, focusing on the aspect that the government cannot have the arbitrary and unlimited power to make decisions, but yet it is important and necessary party of a constitutional democracy. Constitutionalism is the complete opposite of arbitrary authority. To put it another way, constitutionalism is the belief that the government's jurisdiction should be restricted and that these restrictions apply to the legislative, executive, and judicial branches of the government. On the other hand, a veritable constitution aims to curtail and eliminate any kind of arbitrariness. Therefore, constitutionalism assumes strong limits on the government's total authority to prevent citizens' liberties from being restricted without justification. What is and is not reasonable primarily depends on the goal behind any limitations placed on the citizens' specific freedoms. In turn, the prevalent social consciousness dictates this goal. In a rigid society, the extent of citizens' rights is protected by custom, legislation, and the application of the law as it stands. However, in a dynamic society, especially the modern society, the breadth of citizens' liberties is sought to be increased in order to guarantee their equality before the law and eventually their greater equality in the socio-economic domain. Therefore, constitutionalism must be used as a tool for social change if it is to be pursued in any society to the point where it leads logically. However, the liberal interpretation of constitutionalism essentially considers it as a mechanical idea, associating it with some forms of restraint on the arbitrary powers of the state. To fully appreciate the significance of Keshwananda Bharati, we must understand its historic context. In the early years of India's republic, there was a growing concern about the extent to which Parliament could amend the constitution. The Supreme Court of India, for 17 long years, had adhered to the conventional wisdom wherein they sparingly used their power of judicial review to consider the validity of the constitutional amendments. However, thereafter the court felt the need to lay down the limitations on such powers of the legislature. Several constitutional amendments had raised questions about whether the parliament amending power was limitless. This backdrop set the stage for the Keshwananda Bharati's case. The question that arose in Keshwananda Bharati also aimed to discern the powers of the parliament and the degree to which it could amend the laws. The judgment in Keshwananda Bharati versus State of Kerala 1973, 4 Supreme Court cases 2-5, arose out of 6 writ petitions involving common questions as to the validity of the 24th, 25th, and 29th amendments to the Constitution. The matter was admitted by a 5-judge bench and referred to the 13th judge bench, which heard the matter over 6 months and finally culminated into a 701-page judgment through 11 opinions. The petitioner in the lead matter, Keshwananda Bharati, was the head of a Hindu religion mutt in Kerala, challenged the Kerala Land Reforms Act, which sought to impose restrictions on the management and disposal of the property owned by religious institutions. However, the case soon transcended this specific matter and evolved into a constitutional challenge against the power of the Indian Parliament to amend the Constitution at its discretion. He filed the writ petition on March 21st, 1970, under Article 32 of the Constitution of Enforcement of His Fundamental Rights, under Article 25, 26, 14, 19, subclause 1F and 31 of the Constitution, praying that the provisions of the Kerala Land Reforms Act 1963, as amended by the Kerala Land Reforms Amendment Act 1969, be declared unconstitutional, ultra vires, and void. During the pendency of the writ petition, the Kerala Land Reforms Amendment Act 1971 was passed, which received the assent of the President on August 7, 1971. The petitioner filed an application for permission to urge additional grounds and to expunge the constitutional validity of the Kerala Land Reforms Amendment Act 1971. Prior to Keshwananda, the Supreme Court in Golaknath versus State of Punjab had dealt with similar issues regarding the amendment powers of the Parliament and the amendability of fundamental rights. Some of the questions raised therein were as to whether the Constitution is intended to be permanent and therefore it can be amended in a way which would injure, maim, or destroy its indestructible character. Number 2, the word amendment implies such as addition or change within the lines of the original instrument as will affect an improvement or better carry out the purpose for which it was framed, and it cannot be so construed as to enable the Parliament to destroy the permanent character of the Constitution. An 11-judge bench heard and decided the Golaknath case by a thin majority of 6-5 and held that in view of Article 13, subclause 2, fundamental rights could not be abridged or taken away. The minority decision of 5 judges held that Article 13, subclause 2 was inapplicable to acts amending the Constitution. The Supreme Court held that the power of Parliament to amend the Constitution was located in Articles 245 to 248, read with Entry 97, List 1, and Article 368, only contained the procedure thereof. In order to constitutionally nullify and supersede the judgment in Golaknath, Parliament enacted the 24th Amendment to the Constitution, laying down that power of amendment is unrestricted, and Article 368 contains both power and procedure to amend the Constitution. It was also provided that Article 368 and 13 are mutually exclusive, and amending power of Parliament has a limited plenitude. Article 368 of the Constitution also provides for the power and procedure to amend the Constitution. It is a constituent power sui generis in nature, and its validity cannot be questioned as there is no higher law to test it. The Constitution, being the basic norm, is valid in itself. If the prescribed procedure is followed in passing an amending bill, the Constitution shall stand amended in accordance with the terms of the bill. It prescribes a special majority for passing constitutional amendments. An amendment bill under Article 368 must be passed in each house by a majority of the total membership of that house and a majority of not less than 2/3 of the members of that house present and voting. If the bill concerns state matters as detailed in the proviso, it must be ratified by at least half of the state's legislatures before it is sent for assent of the President.
The next time the issue came before the Supreme Court was 13 years later in Sajjan Singh versus State of Rajasthan, AIR 1965, Supreme Court 845. In this case, the 17th Amendment made in 1964 was challenged on the same ground. This time, the court by majority of 3:2 held as before that the amending power conferred by Article 368 is the wide power and includes the power to take fundamental rights guaranteed by Part 3 and could not be controlled by Article 13. This decision essentially bridged the gap between constitutional flexibility and stability, creating a dynamic and involving constitutional framework, and has allowed India to navigate and the complexities of the diverse and ever-changing society. Hegde and Mukherjee justices expressed the same opinion. They said, though the power to amend the constitution under Article 368 is a very wide power, it does not yet include the power to destroy or emasculate the basic elements or the fundamental features of this constitution. Justice Khanna, as he then was, held that the amending power of Parliament is very wide under Article 368, but he also imposed certain limitations on the amending power in the name of basic structure of the Constitution. He said, I quote, "It's permissible under the power of amendment to effect changes howsoever important and to adapt the system to the requirements of changing conditions. It is not permissible to touch the foundation or to alter the basic institutional pattern. The world's amendment of the Constitution, with all their wide sweep and amplitude, cannot have the effect of destroying or abrogating the basic structure or framework of the Constitution." I unquote. Basic structure and the limitation approach. In Keshwananda Bharati, the Supreme Court propounded the no widely known doctrine of basic structure. This doctrine was based upon the concept of limitation. This means that there is a limitation to the extent to which the Parliament may amend the Constitution. In this case, the court upheld the 24th and 29th Amendment Act. However, it struck down the privative clause of the 25th Amendment Act. It was held that the power of the Parliament to amend the Constitution is subject to implied limitation, and there are certain essential features or the basic structure of the Constitution which are not open to amendment. While the court in Golaknath had let down the theory of non-amendability of fundamental rights, the court in Keshwananda Bharati let down the theory of non-amendability of basic structure of the Constitution. That came to life the no popularly known and part of every legal vocabulary, the concept of the basic structure doctrine. However, one may ask, what is the basic structure doctrine? The judgment in Keshwananda Bharati did not give an exhaustive list as to what comprised basic structure, nor did it give any tests to prove what would constitute basic structure, but it did give an elaborate discussion of what comprises of basic structure of the Constitution. It was held that the preamble relates to the basic structure or framework of the Constitution. It was also opined that the basic structure of the Constitution is not a vague concept, and the apprehensions expressed that neither the citizens nor the Parliament would be able to understand it is unfounded. If the historical background, the preamble, the entire scheme of Constitution, the relevant provisions thereof, including Article 368, are kept in mind, there can be no difficulty in discerning that the following can be regarded as the basic elements of the constitutional structure. Jagmohan Reddy, Justice, as he then was, stated that elements of the basic features were to be found in the preamble of the Constitution and the provisions into which they are translated, such as sovereign democratic republic, parliamentary democracy, 3 organs of the state, but the list was not exhaustive. The majority opinion in Keshwananda Bharati held that every provisions of the Constitution can be amended, provided in the result if the basic foundation and structure of the Constitution remains the same. The basic structure doctrine's relevance has not diminished over the decades. It still continues to serve as the bulwark against attempts to alter the Constitution in ways that would undermine its core values. The doctrine also ensures that the Constitution remains adaptable and responsive to evolving societal needs while preserving its foundational principles. In 2007, the Supreme Court in I.R. Koholo versus State of Tamil Nadu 2007, 2 Supreme Court cases 1, reaffirmed the doctrine of basic structure and the power of judicial review in safeguarding fundamental rights. It did clarify that laws included in the 9th schedule were not immune from constitutional scrutiny if they violated the basic structure. It was clarified that the doctrine of basic structure contemplates that there are certain parts of aspects of the Constitution, including Article 15, Article 21, to be read with Article 14 and Article 19, which does constitute the core values, which if allowed to be abrogated, would change completely the nature of the Constitution. Exclusion of fundamental rights would result in nullification of the basic structure doctrine, the object of which is to protect basic features of the Constitution as indicated by the synoptic view of the rights in Part 3. It was held that Part 3 is amenable, subject to basic structure doctrine. It is permissible for the legislature to amend the 9th schedule and grant a law the protection in terms of Article 31 capital B, but subject to right of citizen to assail it on the enlarged judicial review concept. The legislature cannot grant fictional immunities and exclude the examination of the 9th schedule law by the court after the enunciation of the basic structure doctrine, and the constitutional amendments are subject to limitations, and if the question of limitation is to be decided by Parliament itself, which enacts the impunged amendments and gives that law a complete immunity, it would disturb the checks and balances in the Constitution. The authority to enact law and decide the legality of the limitations cannot vest in one organ. The validity to the limitation on the rights in Part 3 can only be examined by another independent organ, namely the judiciary. The doctrine of basic structure as a principle has now become an axiom. It is premised on the basis that invasion of certain freedoms needs to be justified. It is the invasion which attracts the basic structure doctrine. Certain freedoms may justifiably be interfered with. Therefore, such an exercise, if challenged, has to be tested on the touchstone of basic structure as reflected in Article 21, to be read with Article 14 and Article 19 and Article 15 and the principles thereunder. First, the violation of rights of Part 3 is required to be determined, then its impact examined, and if it shows in effect and substance, it destroys the basic structure of the Constitution. The consequence of invalidation has to follow. Every time such amendment is challenged, to hard back to Keshwananda Bharati's case. Upholding the validity of Article 31, capital B, is a surest means of a drastic erosion of the fundamental rights conferred by Part 3. The doctrine of basic structure has been since used as a constitutional benchmark. In many cases, the same was widely discussed in Supreme Court Advocates on Record Association versus Union of India, 2016, 5 Supreme Court cases 1. Case wherein the petitioners questioned the validity of the Constitutional 99th Amendment Act 2014 and the National Judicial Appointments Commission Act 2014, through which the Parliament amended the Constitution to empower itself to make regulations on appointment of judges to constitutional courts. It formulated a commission which would recommend the appointment of judges to the President to make it balanced and not only controlled by the executive. The commission was to consist of 3 members from the apex court, 1 member from the government law minister, and 2 others eminent personalities, who would be nominated by the high-powered committee with the Prime Minister, Leader of the Opposition, and Chief Justice of India as members. The committee also had a check on its functioning. If 2 members oppose a recommendation, the recommendation shall not or cannot be passed. Finally, the recommendation of the NJAC shall or cannot be questioned, or just because there is a vacancy or a defect in the constitution of the commission. The Supreme Court, though, its judgment dated 16th of October 2015, did declare that the impunged amendment and the act were unconstitutional, and held that the new scheme damages the basic feature of the constitution, under which primacy in appointment of judges has to be with the judiciary, and such primacy was not given in the new scheme. The decision given in this case became a constitutional benchmark. While it most necessarily changed the constitutional jurisprudence in India, it also affected the legal atmosphere in other countries, which took inspiration from the detailed legal exercise undertaken by the Supreme Court of India. In 1989, the Supreme Court of Bangladesh in Anwar Hussain Chaudhry versus Bangladesh 1981, popularly known as the 8th Amendment case, is considered as milestone in the constitutional history of Bangladesh. The Supreme Court of Bangladesh in this case adopted the basic structure doctrine, primarily relying on the decision delivered in Keshwananda Bharati. Conclusion: In the decades following this ruling, the Supreme Court of India has continued to reaffirm and clarify the doctrine of basic structure, ensuring that the essential tenets of the Indian Constitution remains inviolable. The Keshwananda Bharati judgment has become a shield against any attempts to alter the constitutional fundamental character, serving as a bulwark of Indian democracy. In conclusion, the Keshwananda Bharati judgment demonstrates the resilience and the thought process of Indian legal system, which has preserved democratic and legal values. It does serve as a reminder that the Indian Constitution is the soul of the country's democratic values and should be preserved and protected above all else. It is not just a legal instrument, but a living document which needs constant reading, learning, and unlearning. We are reminded of the timeless significance of constitutional ideas and the critical role the court plays in defending them as we consider Keshwananda Bharati's case. As we conclude this exploration of constitutional law in India, it is essential to emphasize the enduring significance of our Constitution. The Constitution is an embodiment of our national identity, a testament to our commitment to justice, liberty, equality, and fraternity, and continues to be the beacon that guides us through the complexities and challenges of a dynamic and diverse nation. It stands as a reminder of our shared values, our dedication to democratic principles, and our promises of a better future for all citizens. As a students, scholars, and future legal practitioners, it is a responsibility to engage with and uphold the principles of our Constitution. We must therefore ensure that it remains a living, breathing document that reflects the aspirations and rights of all Indians. Thank you.
Thank you so much, Dr. Rahul, for the lecture that you have delivered as of now on behalf of Shri A.S. Bopanna, Judge, Supreme Court of India. Thank you, sir, so much for the intellectually stimulant, thought-provoking ideas and the kind of encouragement that has been provided to one and all, being a part of the whole larger framework of this legal fraternity. Thank you so much, sir. I take this moment on behalf of Manipal Law School to acknowledge the presence of special dignitaries who have joined with us. I thank each and every one of them. Shri Santosh S. Gogi, Additional Advocate General. Mr. Aruna Sham, former Additional Advocate General. Mr. Shanti Bhushan, ASG, Government of Karnataka. Mr. Manmohan PN, Senior Advocate, Karnataka High Court. Mr. D. Krishnamurthy, Senior Advocate, Karnataka High Court. From the academia, we have two principals who have joined us, Srimati Karthika, Principal Dr. B.R. Ambedkar Law College, Bengaluru, and we have Mr. Sendil Kumar, Principal Balaji College of Law. We really acknowledge your presence over here and for having joined with us. Thank you so much to all those special dignitaries over here. Now I call upon Dr. C.G. Manjunatha to introduce Shri H.H. Sachidananda Bharathi Swamiji, Pontiff, Edneer Mutt, Kerala.
Be certain that you do not die without having done something wonderful for the humanities. Good morning to all of you, respected dignitaries on the dais and the august gathering on this auspicious day. It is my honor and a privilege stand here to introduce the today's guest of honor, Shri H.H. Sachidananda Bharati Swamiji. Shri H.H. Sachidananda Bharati Swamiji is a Hindu saint, spiritual master, and the religious leader. Shri H.H. Sachidananda Swamiji's contribution towards the society is enormous. Sachidananda Swamiji is a last seer from the Manjunathaya family to lead Edneer Mutt in Kasaragod. Swamiji is the successor of Keshwananda Bharati, and Swamiji is the present Pontiff of Energy Mutt in Kerala. So as we know, the Edneer Mutt is known for cultural excellence because of their contribution towards the societies. So Edneer Mutt is providing a lot of facilities to the societies in terms of Annadana, and they have introduced many of the artists to the society. At the same time, that Edneer Mutt providing various facilities such as an education institution for the underprivileged societies people. At the same time, they're providing temporary shelter to the people who really need it. At the same time, Shri H.H. Sachidananda Bharathi Swamiji is the present leader and the spiritual continuous leading of that Edneer Mutt. Thank you.
ओम नमः प्रणवार्थाय शुद्धज्ञानैकमूर्तये निर्मलाय प्रशांताय दक्षिणामूर्तये नमः. अत्यन्तबालम् अतसी कुसुमप्रकाशं दिग्वाससं कनकभूषणभूषिताङ्गं विसृस्तकेशम् अरुणाधरं मायताक्षं कृष्णं स्मरामि मनसान्वनीतहस्तं. सदाशिवसमारम्भां शङ्कराचार्यमध्यमाम् अस्मदाचार्यपर्यन्तां वन्दे गुरुपरम्पराम्. ಕನ್ನಡ ಅರ್ಥ ಆಗ್ಬೋದು ಮತ್ತು ಅರ್ಥ ಆಗಬೇಕು ಅನ್ನುವ ಆಶಯದೊಂದಿಗೆ ಕನ್ನಡದಲ್ಲೇ ಮಾತಾಡ್ತಾ ಇದ್ದೇನೆ. ಮಣಿಪಾಲ ಲಾ ಸ್ಕೂಲ್ ಬೆಂಗಳೂರು ಇದರ ಆಭಿಮುಖ್ಯದಲ್ಲಿ ಶ್ರೀ ಕೇಶವಾನಂದ ಭಾರತಿ ಮೊಕದ್ದಮೆ ಇದರ 50ನೇ ವರ್ಷದ ಆಚರಣೆಯ ಅಂಗವಾಗಿ ಒಂದು ವಿಚಾರ ಸಂಕಿರಣ ಇವತ್ತು ಈ ಲಾ ಸ್ಕೂಲಿನ ಈ ಸಭಾಮಂಟಪದಲ್ಲಿ ನಡೀತಾ ಇರೋದು ಖಂಡಿತವಾಗಿ ನಮಗೆ ಸಂತೋಷದ ವಿಷಯ. ಈಗಾಗಲೇ ಅದರ ಬಗ್ಗೆ ಆ ಕೇಸಿನ ಬಗ್ಗೆ ತಾಂತ್ರಿಕವಾಗಿ ನ್ಯಾಯ ವಿದಗ್ಧರು ಮಾತಾಡಿದರು ಮತ್ತು ಇನ್ನು ಮಾತಾಡಲಿಕ್ಕೂ ಇದ್ದಾರೆ. ನಮ್ಮ ದೇಶದಲ್ಲಿ ನ್ಯಾಯ ಬೇರೆ ಅಲ್ಲ, ಧರ್ಮ ಬೇರೆ ಅಲ್ಲ. ನ್ಯಾಯದಲ್ಲಿ ನಡ್ಕೊಳ್ಳೋದೇ ಧರ್ಮ ಮಾರ್ಗದಲ್ಲಿ ನಡ್ಕೊಳ್ಳೋದು ಮತ್ತು ಅದನ್ನೇ ನಮ್ಮ ಸ್ಮೃತಿಗಳು ಹಿಂದಿನ ನಮ್ಮ ಋಷಿಮುನಿಗಳು ಕೂಡ ಅದನ್ನೇ ನಮಗೆ ತಿಳಿಸಿದ್ದಾರೆ. ಆ ನಿಟ್ಟಿನಲ್ಲಿ ಇವತ್ತು ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಧಾರ್ಮಿಕ ಕ್ಷೇತ್ರದ ಒಬ್ಬ ಸಂತರ ಹೆಸರು ಈ ರೀತಿಯಲ್ಲಿ ಒಂದು ಮೊಕದ್ದಮೆಯ ಮೂಲಕ ಹೆಸರು ಮಾಡಿದೆ ಅಂದರೆ ಅದು ಖಂಡಿತವಾಗಿ ನಮಗೆ ಧಾರ್ಮಿಕ ಕ್ಷೇತ್ರಕ್ಕೆ ಒಂದೊಂದು ಹೆಮ್ಮೆಯ ಸಂಗತಿ. ಮತ್ತು ಆ ಸಂತ ನಮ್ಮವರು ಅನ್ನೋದು ಇನ್ನಷ್ಟು ಸಂತೋಷದ ವಿಚಾರ. 70ರ ದಶಕದ ಪ್ರಾರಂಭದಲ್ಲಿ ಕೇರಳ ಭೂಮಸೂದೆ ಕಾಯ್ದೆ ಬಂದಂತಹ ಸಮಯದಲ್ಲಿ ಶ್ರೀಮಠದ ಸುಮಾರು 400-500 ಎಕರೆಗಳಷ್ಟು ಆಸ್ತಿ ಮಠದಿಂದ ತಪ್ಪಿ ಹೋದಾಗ ಸ್ವಾಭಾವಿಕವಾಗಿ ಪೂಜ್ಯ ಸ್ವಾಮೀಜಿಯವರು ಅದರ ವಿರುದ್ಧವಾಗಿ ಮೊಕದ್ದಮೆಯನ್ನು ಹೂಡಿದರು. ಒಂದು ಅರ್ಥದಲ್ಲಿ ಸೋತು ಗೆದ್ದಂಥ ಒಂದು ಮೊಕದ್ದಮೆ ಅದು. ಶ್ರೀಮಠಕ್ಕೆ ಸೋಲಾದರೂ ಕೂಡ ನಾವು ಗೌರವಿಸುವಂತಹ ನಮ್ಮ ದೇಶದ ಸಂವಿಧಾನಕ್ಕೆ ಅದು ಗೆಲುವಾಯಿತು ಅನ್ನೋದು ಸ್ಪಷ್ಟವಾದಂಥ ಒಂದು ವಿಚಾರ. ಅಂಥ ಒಂದು ಶ್ರೇಷ್ಠವಾದಂಥ ಫಲಶ್ರುತಿ ಆ ಮೊಕದ್ದಮೆಯ ಮೂಲಕ 1973 ಏಪ್ರಿಲ್ 24ರಂದು ಹೊರ ಬಂದದ್ದು ಖಂಡಿತವಾಗಿಯೂ ಸಂವಿಧಾನದ ದೃಷ್ಟಿಯಿಂದ ನಮಗೆ ಅದೊಂದು ಹೆಮ್ಮೆಯ ವಿಷಯ. ಆ ನಿಟ್ಟಿನಲ್ಲಿ ಈ ಮೊಕದ್ದಮೆಯ 50ನೇ ವರ್ಷದ ಆಚರಣೆಯನ್ನು ನಾವು ಶ್ರೀಮಠದಲ್ಲಿ ಸೆಪ್ಟೆಂಬರು 2ನೇ ತಾರೀಕಿನಂದು ನಾವು ಹಮ್ಮಿಕೊಂಡಿದ್ದೆವು. ನಮ್ಮ ಅತ್ಯಾಪ್ತರಾದಂಥ ಅಭಿಮಾನಿಗಳಂಥ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಶ್ರೀ ಅರುಣ್ ಶ್ಯಾಮ್ ಅವರು ಬಂದಿದ್ದಾಗ ಅದರ ಬಗ್ಗೆ ಮಾತಾಡಿದಾಗ ಅವರ ಮುತುವರ್ಜಿಯಿಂದಾಗಿ ಆ ಕಾರ್ಯಕ್ರಮ ಬಹಳ ಸೊಗಸಾಗಿ ಮೂಡಿಬಂತು ಮತ್ತು ಅದರ ಫಲಾನುಭವಿಗಳಾಗಿ ಅತ್ಯಂತ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿಗಳು ಕೂಡ ಪಾಲ್ಗೊಂಡದ್ದು ನಮಗೆ ಸಂತೋಷದ ವಿಷಯ. ಇವತ್ತು ಅಂತಹ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ಈ ಮಣಿಪಾಲ ಲಾ ಸ್ಕೂಲಿನ ಆವರಣದಲ್ಲಿ ಹಮ್ಮಿಕೊಂಡದ್ದು ಖಂಡಿತವಾಗಿಯೂ ನಮ್ಮ ಗುರುಗಳಿಗೆ ನೀಡಿದಂಥ ಒಂದು ಗೌರವ ಅನ್ನೋದಾಗಿ ನಾವು ಭಾವಿಸ್ತಾ ಇದ್ದೇವೆ. ಮುಖ್ಯವಾಗಿ ಸಂವಿಧಾನ ಗೌರವಿಸಲ್ಪಟ್ಟಾಗ ಎಲ್ಲ ಪ್ರಜೆಗಳಿಂದ ಅದಕ್ಕೆ ಸಲ್ಲಬೇಕಾದಂಥ ಗೌರವ ಸಂದಾಗ ದೇಶದಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಂತಹ ಗೊಂದಲಗಳು ಏರ್ಪಡಲಿಕ್ಕೆ ಅದು ಕಾರಣವಾಗೋದಿಲ್ಲ. ಅಂಥ ಒಂದು ಬದ್ಧತೆ ನಮ್ಮ ಎಲ್ಲ ಪ್ರಜೆಗಳಿಗೆ ಇರಬೇಕು. ಆಗ ಮಾತ್ರ ದೇಶ ಸುಭಿಕ್ಷವಾಗಿರುತ್ತದೆ ಮತ್ತು ಯಾವುದೇ ಗೊಂದಲಗಳಿಲ್ಲದೆ ದೇಶ ಮುಂದುವರಿಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. ಇವತ್ತಿನ ಪ್ರಸ್ತುತ ಕಾಲಘಟ್ಟದಲ್ಲಿ ಹಲವಷ್ಟು ಗೊಂದಲಗಳನ್ನು ನಮ್ಮ ಸಮಾಜದಲ್ಲಿ ಕಾಣ್ತಾ ಇದ್ದೇವೆ. ಈಗಾಗಲೇ ಇಲ್ಲಿ ದೀಪ ಪ್ರಜ್ವಲನ ಮಾಡುವಾಗ ಮಂತ್ರ ಹೇಳಿದರು, ಶತ್ರು ಬುದ್ಧಿ ವಿನಾಶಾಯ ದೀಪಜ್ಯೋತಿರ್ನಮೋಸ್ತುತಿ ಎಂದು. ನಮ್ಮ ವೈದಿಕ ಮಂತ್ರಗಳು ಕೂಡ ಅದನ್ನೇ ಸಾರಿವೆ. ಯಾಕೆಂದರೆ ನಾವು ಯಾವತ್ತೂ ನಮ್ಮ ಸಂಸ್ಕೃತಿ ಶತ್ರುಗಳು ನಾಶವಾಗಲಿ ಅಂತ ನಾವು ಪ್ರಾರ್ಥಿಸುವುದಿಲ್ಲ, ಶತ್ರು ಬುದ್ಧಿ ನಾಶ ಆಗಲಿ ಅಂತ ನಾವು ಪ್ರಾರ್ಥಿಸ್ತೇವೆ. ಮನುಷ್ಯನಲ್ಲಿರುವಂತಹ ಶತ್ರು ಬುದ್ಧಿ ನಾಶ ಆದರೆ ಎಲ್ಲರಲ್ಲೂ ಅಂತಹ ಒಂದು ವ್ಯತಿರಿಕ್ತವಾದಂತಹ ಭಾವನೆಗಳು ನಾಶ ಆದರೆ ಖಂಡಿತವಾಗಿಯೂ ದೇಶ ಯಾವತ್ತೂ ನ್ಯಾಯ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಮುಂದುವರಿಯುತ್ತದೆ ಮತ್ತು ಅತ್ಯಂತ ಸುಸ್ಥಿತಿಯಿಂದ ಇರಲಿಕ್ಕೆ ಕಾರಣ ಆಗ್ತದೆ. ಆ ರೀತಿಯಾದಂಥ ಬುದ್ಧಿಯನ್ನು, ಆ ರೀತಿಯಾದಂಥ ಸುಮನಸ್ಸನ್ನು ಎಲ್ಲ ನಮ್ಮ ಪ್ರಜೆಗಳಿಗೆ ನಾವು ನಂಬಿದಂಥ ದೇವರು ನೀಡಲಿ. ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಇನ್ನಷ್ಟು ಹೆಚ್ಚಿನ ರೀತಿಯಲ್ಲಿ ನಮ್ಮ ಭಾರತ ಬೆಳಗಲಿ, ವಿಶ್ವ ಗುರುವಾಗಿ ಬೆಳಗಲಿ ಅನ್ನುವಂಥ ನಮ್ಮ ಪ್ರಾರ್ಥನೆಯೊಂದಿಗೆ ಕೆಲವು ದಿನಗಳ ಹಿಂದೆ ನಮ್ಮ ಆತ್ಮೀಯ ಅಭಿಮಾನಿಗಳಂಥ ನಮ್ಮವರೇ ಆದಂಥ ಶ್ರೀ ವಸಂತ ಕೃಷ್ಣ ಅವರು ಈ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ತಿಳಿಸಿದರು. ಸಂತೋಷದಿಂದ ಒಪ್ಪಿಕೊಂಡು ಇವತ್ತು ಇಲ್ಲಿ ಬಂದಿದ್ದೇವೆ. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಚಂದಗಾಣಿಸಿದ್ದಾರೆ. ಇವತ್ತು ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾದಂತಹ ಜಸ್ಟಿಸ್ ಇಂದ್ರೇಶ್ ಅವರು ಕೂಡ ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಅಂತೆಯೇ ನಲ್ಸಾರ್ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರೊಫೆಸರ್ ಶ್ರೀಕೃಷ್ಣ ದೇವರಾವ್ ಅವರು ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಇವತ್ತು ಕಾರ್ಯಕ್ರಮವನ್ನು ಉದ್ಘಾಟಿಸಿದಂತಹ ಈ ಮಾಹೆ ಬೆಂಗಳೂರು ಕ್ಯಾಂಪಸ್ನ ವೈಸ್ ಚಾನ್ಸಲರ್ ಶ್ರೀ ಪ್ರೊಫೆಸರ್ ಮಧು ವೀರರಾಘವನ್ ಅವರು ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಸ್ವಾಗತ ಭಾಷಣವನ್ನು ಮಾಡಿದಂಥ ಶ್ರೀ ಅವಿನಾಶ್ ದದೀಚ್ ಅವರು ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಅಂತೆಯೇ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪಾಲ್ಗೊಂಡಂಥ ಎಲ್ಲ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ಎಲ್ಲ ಪ್ರಾಧ್ಯಾಪಕರು, ಈ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥರು, ಅಂತೆಯೇ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳು ನೀವು ಇಲ್ಲಿ ಉಪಸ್ಥಿತರಿದ್ದೀರಾ. ಎಲ್ಲರಿಗೂ ನಮ್ಮ ಆತ್ಮೀಯ ಅಭಿಮಾನಗಳನ್ನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ತಿಳಿಸ್ತಾ ಮತ್ತೊಮ್ಮೆ ಬಂದಂತಹ ಎಲ್ಲರಿಗೂ ನಮ್ಮ ಆರಾಧ್ಯ ಮೂರ್ತಿಗಳಾದ ಶ್ರೀ ದಕ್ಷಿಣಾಮೂರ್ತಿ ಗೋಪಾಲಕೃಷ್ಣ ಸ್ವಾಮಿ ಆಯುರಾರೋಗ್ಯ ಭಾಗ್ಯಗಳನ್ನು ನೀಡಿ ಹರಸಲಿ ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ವಿಶೇಷವಾದ ಪ್ರಾರ್ಥನೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಇಲ್ಲಿ ಹಮ್ಮಿಕೊಂಡಂತಹ ಎಲ್ಲ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥರಿಗೆ ನಮ್ಮ ಆತ್ಮೀಯ ಅಭಿನಂದನೆಗಳೊಂದಿಗೆ ಮಾತಿನಿಂದ ವಿರಮಿಸ್ತಾ ಇದ್ದೇನೆ. ಸರ್ವೇ ಜನಾಃ ಸುಖಿನೋ ಭವಂತು. ಓಂ ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ.
Our humble pranams to Swamiji, and to again reiterating the essence of oneness and the unity of the soul, and the relationship between the soul and the experienced world or the reality. Thank you so much, Swamiji. Now I would like to call upon Dr. Engalaguppe to introduce Honorable Shri E.S. Indiresh, Judge, High Court of Karnataka, Bengaluru, for the special address.
Respected guests and ladies and gentlemen, I am privileged to introduce the High Court Judge of Karnataka, Hon'ble Mr. Justice E.S. Indresh. He obtained degree in law from Sharada Vilas College at Mysore and LLM from University of Mysore. So secured first rank in constitutional law branch. In the year 1996, he enrolled as an advocate in the Karnataka State Bar Council and joined the office of leadership B.V. Nagaratna, who is presently serving as judge of Hon'ble Supreme Court of India. He was a panel advocate for Mysore Sugar Company, KSFC, Karnataka Marketing Federation, Oriental Insurance Company, United India Insurance Company, and so on. Honorable Mr. Justice E.S. Indiresh worked as part-time lecturer in Sharada Vilasa Law College, Mysuru, and later worked at Havanur College of Law and Bangalore Institute of Legal Studies. He was a regular faculty at Karnataka Police Academy and served as government pleader and as additional government advocate between 2009 till elevation. Honorable Mr. Justice E.S. Indiresh appointed as an additional judge of the Karnataka High Court on February 2020 and as a permanent judge on September 2021. Please.
ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರ. ಗುರುವೇ ಸರ್ವಲೋಕಾನಾಂ ವಿಷಜೇ ಭವರೋಗಿಣಂ ನಿಧಿಯೇ ಸರ್ವವಿದ್ಯಾನಾಂ ವೃಕ್ಷರಾಜಾಯ ತೇ ನಮಃ. Dear friends, I stand before you as a fifth-year law student and not a judge of the High Court. Insofar as the legal system is concerned, there are two judgments that have made a landmark in the world. One is relating to public law and another is relating to private law. Insofar as the public law is concerned, a renowned judgment rendered by Justice Holmes in Marbury versus Madison in US Supreme Court, where the concept of the judicial review was enunciated. First time, because in US we know there is a packing of judges, appointment of judges, and many problems over there. Insofar as the private law is concerned, the Lord Atkin judgment in Dunag versus Stevenson, popularly I think you must have seen in respect of the civil wrong is concerned. Doctrine of the neighbor principle was enunciated by Lord Atkin in 1911. Even now we remember those cases. But insofar as, apart from these two cases in the world, one more judgment where equally important, following, and definitely it is going to be cherished in future, is none other than the judgment rendered by our Supreme Court in Keshavananda Bharathi. See, dear friends, insofar as the Keshavananda Bharathi case is concerned, we all of us know that Indian Constitution is a living document. And it's not a document or not just articulates certain powers and the rules providing for the three wings of the government. And there is no better case to elaborate the gamut of the provisions under the Constitution except the judgment rendered by the Honorable Supreme Court in Keshavananda Bharathi. Because if you look at after the Cripps mission, the Constituent Assembly was constituted. The members of the Constituent Assembly were influenced not merely insofar as the laws which was prevailing during that time. They have seen what has happened in Regulating Act 1973. They are aware about the fact that the 1861 Act, then Montego Chelmsford, 1909, Minto Morley, 1909, 1935 Act, and the 1947, that's what the division of the two regions. That means what I would like to say, they had the experience of what is needs to be given to the Indian people. With this, the Constitution is nothing but the wisdom, a testament to the wisdom of founding fathers and a guiding light for a democratic and pluralistic society. If you look at the Indian Constitution, it is a blend of ideals that shape the every essence of what we require by the Indian people. I feel that recently we have a discussion in media whether the largest ever judgment rendered by the Supreme Court requires a relook, whether it has to be looked into. Perhaps the reason is quite obvious, dear friends. We may say that the reason is quite obvious. The firstly, I would say this is an attack on the freedom of expression in the country. Secondly, insofar as the deterioration of quality of elections. And thirdly, lead to rethink about insofar as to underline the objects of the democratic principles. These are all the three reasons where we can see after the last 5-6 years, we can see a number of where the talks are going on. See to that whether the Keshavananda Bharathi case has to be relooked or not. But in my personal opinion, there is no relook is required at all. Because the basic feature, dear friends, it was not insofar as enunciated by in the Keshavananda Bharathi case itself alone. If you take from Shankari Prasad case, 1951, where the first amendment was challenged, where the Constitution bench in that judgment held that the Parliament can interfere with the amending power. But if you look at the provisions under 368 and 32 class 2 of the Indian Constitution, where earlier the power to amend was there. Thereafter it was amended, procedure to amend. Nextly, insofar as 13 class 2 is concerned, there is one word, law, if you look at law. Whether that law is a constituent law to amend the Constitution itself or any other law, legislation like the other statutory provisions. Those aspects have been considered in first amendment itself. Of course, we should be very grateful to the first 7 judges of the Indian Supreme Court, Patanjali Shastri, Venkatramaiah, Kania, particularly the Vivian Bose, where he rendered the very famous case, the Anwar Ali Sarkar case, relating to Article 14, where Article 14, 19, and 21. In that case, insofar as we can see the seed of, there is something in the Indian Constitution which does not require any amendment. Amend means delete or add. But insofar as these aspects is concerned, the Supreme Court, insofar as after Sajjan Singh, insofar as Sajjan Singh, where the 17th Amendment was challenged, and thereafter the aspects relating to the I.C. Golaknath case, where the judgment rendered, of course, rendered by the K. Subra, known for his dissenting opinion. But finest judgment we can see by Honorable Justice Subra insofar as the I.C. Golaknath case is concerned. Therefore, first I will say my conclusion that there should not be any discussion relating to all these aspects. We need not discuss whether it requires reconsideration at all. It is nothing but a misnomer. Just like how Montesquieu, when he has enunciated separation of power, then a lot of criticisms was made, whether it's a separation of power or separation of function, because power you cannot be indivisible. Power is always lies with the one organ, that is nothing but Constitution itself. If you look at the Constitution itself, is a grannorum, Kelson's pure theory is there. All the organs of the government, they draw their functions from the pyramidical structure of the Grand Europe as called out by the Kelson's pure theory of law, or whether it considers a positivism, a law is a command of sovereign. Absolutely, because Constitution is the supreme, we are bound by that. We ourselves has adopted, and in the preamble we ourselves have stated that we the people of India. When such being the case, I would say certain values that we have already adopted, followed, not from now, from time immemorial. One is democratic principles. Secondly, republican, and adopted the written constitution. Insofar as a written constitution is concerned, because if you want to change certain things, it's not possible. If something is written, we are bound by that. These are all the values where they are constitutionally inseparable. Even take for an example fundamental rights. You cannot separate the constitutional rights with the democratic principles. If you say the democratic principles are there, there should be the constitutional rights. You may say human rights, or you may say fundamental rights, or you may say the Solomon says the law is a dictate of reason. These are all the aspects you are inseparable in a civil society. If such being the case, I would say there should not be any discussion to really look on these aspects. If you say, because the constitution ethos where we have seen is a grand norm. If such being the case, firstly the democracy, where it is the heart of the Indian constitution, and it lies the commitment to the democracy. At the heart of the Indian constitution, where we the people of India emphasize the sovereignty of the people as the foundation of the Indian state. Take for example, if the power is given to the parliament to amend these aspects, can parliament change the democratic setup? Is it possible in India? That cannot be. Because we have followed for time immemorial. It is a rule. Democracy means democracia. That means rule by many. You cannot change that, because it's a pillar to our Indian constitution. When certain thing is considered to be as a basic feature, something is regarded as a pillar to the Indian constitution, like a democratic principle, then those aspects were under the constituent power, under Article 368, Parliament cannot touch that. Because if you touch democratic, then you cannot say that Indian constitution is given to ourselves. If you say ourselves, then there should not, the Parliament cannot touch democratic principles. Because, but of course, I'm not saying that it is only a living document, dynamic, it has to grow, it has to adapt to the changing in society. But certain aspects were considered to be as a pillar, don't destroy that pillar. Because the reason is, take for an example, change is required in democratic principles is concerned. See, Parliament is empowered to make law to every citizen to participate in the decision-making process, elect their representatives, and hold them accountable. And in a world where authoritarians still persists, Indian dedication to democracy is an inspiration and laudable. See, ours is the largest democracy. We are nearly 140 crores people. Even today we say we believe in parliamentary type of government insofar as the electing the representatives in the parliament, and they are accountable to the house also. Anyway, there is a check is there. When certain checks have been already embedded in the Indian constitution, don't touch these basic features like the democratic principles. That's one thing. Secondly, insofar as our constitution is a written constitution. See, whenever there is a requirement to interpret the provisions of the constitution, because ours is, as I told you, it's a written constitution, without the aid of the Constituent Assembly debate, you cannot interpret the law or the provisions contained under the Indian Constitution. If you read the judgment rendered in the Keshavanna Bharati case, Dear friends, you will get all types of interpretation techniques in the judgment. Whether it's a reading down, reading up, whether it's a purposive, literal, whether it is harmonious construction. All types of the interpretive techniques as stated in the Maxwell's interpretation or GP Singh, everything you will find in the 13 judges' judgment in the Keshavananda Bharati case. That means these 13 judges, not merely the judges according to me, they are all Dharmatmaru. Today we have given this constitution, we are obeying this constitution, we are leaving today entire the 140 crores only because of the judgment rendered by the Honorable Supreme Court in this case. Because in order to interpret any constitutional provisions, without the aid of the Constitutional Assembly, you cannot interpret any provisions. If you look at the Constitutional Assembly debate on this aspect is concerned, see what type of people we have. Alladi Krishna Swamiji, the Ambedkar ji, and H.V. Kamath, many great the Constitutional Assembly members, the founding fathers, they discussed for near more than 2 years, 11 months to bring out a great document. It is not merely just have to stand there, hey, this constitution is not good. Like French, they got 5 constitution over a period of, I cannot say like that. What kind of, the discussion has been made in the Constitutional Assembly. Please read the law students, B. Shivarav's Constitutional Assembly debates. Whenever there is an interpretation of constitutions required to be looked into, we cannot forget B. N. Rao as well as B. Shivarao. They are also from Karnataka, particularly from Udupi. See, they are the one who has contributed a lot to the getting this document as such. Insofar, secondly, the justice is concerned, the Indian Constitution strives for justice in all dimensional, social, economic, and political. The preamble promises justice, social, economic, and commitment is manifest in various provisions. The Indian Constitution recognizes the importance of equitable society and has provisions for affirmative action. If you say that the Indian Constitution is a social document, there's a provision under 14 is there, 15 class 4, 16 class 4 is there to provide social justice to the marginalized people. Can you give interpretation to these provisions by relooking into the Keshavananda Bharati judgment? That cannot be, because now we have transferred from laissez-faireism to the welfareism. Part 4 of the Indian Constitution is there. Minerva Mills has already stated that one must supplement to other. See, these are all the judgments where these are post Keshavananda Bharati, of course in Maneka Gandhi also. These are all the judgments we never had the benefit unless a great thinking have been found in the judgment of the Keshavananda Bharati case. Because various welfare policies taken by the government is within the ambit of justice, whether it's a social, economic, and political. Insofar as fourth aspect is concerned, equality. The Indian Constitution is a champion of equality irrespective of caste, creed, religion, where the equality, fostering harmonious society and to ensure that all individuals have equal, we have seen equal, Article 14, if you say that, it start with the word negative. It start with a word negative. No person deny right to equality and right to power. See, it did not, positive word has been not incorporated. If you look at the constitutional debate on insofar as the incorporation of Article 14 is concerned, something is not, we have borrowed from the Austin's theory of equality before law. Apart from, the diocese constitution, even we have followed equal protection of law also there. So that's the beauty of the Indian Constitution as far as the Article 14 is concerned. Insofar as secularism is concerned, the Ismail Faruqi versus A.S. Narayan Das, there are the judgments where we can see even recent one on Babri Masjid. See, these are all the judgments where the Supreme Court reiterates the judgment rendered in S.R. Bommai, saying that secularism is a basic structure. What is secularism means? Because our constitution, if you look at the provisions, it advocates the secular, ensuring that state does not favor any particular religion as such. And it guarantees freedom of religion and the right to practice and propagate one's faith. These are all the judgments. If you record even Jeevas witnesses in the judgment rendered by the Chinnappareddy's case in national anthem case, right to speak includes right not to speak. If such been the case, why you can't? You can raise a voice insofar as to promoting the values under the Indian Constitution. Don't destroy the certain things were considered to be as an essential feature. It is not only an ancillary one, it is essential to run the country. These are all the essential aspects where we do not interfere with that. And next, insofar as whenever there is a secularism, obviously there will be a concept of the fraternity. Fraternity means common brotherhood. That's also we can see in the Indian Constitution. Because this is a unique aspect of the Indian Constitution that emphasizes the unity in diversity. And insofar as our Constitution is concerned, dear friends, fundamental rights have been guaranteed under Part 3. Indian Constitution guarantees a citizen a comprehensive set of fundamental rights. Maybe we have borrowed from Bill of Rights from US and directive principles from Irish Constitution. Then insofar as the trade and commerce from the Canadian Constitution, or whether we have borrowed the many aspects like this, the parliamentary type of government from the UK. However, insofar as the fundamental rights ensure every citizen is entitled to protection of fundamental freedoms. If there are fundamental rights are there must be a remedy to redress of their. That's what we can see in Article 32. Article 32 itself is in the Part 3 itself. If certain fundamental remedy which is available under the 32 is available under Part 3 itself, that's why you can't imagine. Probably what has transpired the predecessor Swamiji, Keshavananda Bharati too, he directly approached the Supreme Court under Article 32 in that case, not under 226 and thereafter to the 32. Because reason is, maybe it was very quite obvious as probably the Nani Parkewala, when was appearing for the petition in that case, perhaps advised the Keshavananda Bharati, don't go to High Court under 226, go to 32, Supreme Court. Because 32 itself in the article, in Part 3 of the Indian Constitution, then the Supreme Court is bound to give judgment. They cannot just say that certain things, these aspects probably might have been there. Because one thing is, insofar as Keshavananda Bharati's case concerned, the doctrine of basic structure, though it was was considered there, please read the arguments advanced by Nambiar in that case, Nani Palkewalaji, and on the insofar as not only those two people, even on the other side also, the H.M. Shirvai was there for the state of Maharashtra, where for the government, they argued the matter, maybe the outcome of the what basic structure, what we have followed today itself. Instead of the Indian Constitution also promotes quasi-federal system. We have seen under Article 245, where the division of power, diarchy, it was there in 1935 Act. Even we have followed thereafter, both the levels of the government can make law, and 7th schedule is provided for that. Federalism has been considered to be as a basic structure. These are all the aspects, dear friends, where we can say that they are the pillars of the Indian Constitution. Can you change democratic principle? Can you make anything relating to the justice? Can you interfere with the federalism, the concept of federalism in the Indian Constitution? It's not possible at all. Because these are all things as being considered as the essential to run a civil society, to see to it that not necessarily this document as because we have followed this document for more than 70 years. Even 70 years, we abide by this constitution. And also article in Bashisharnath case, if you read, one cannot waive the fundamental rights at all. It was long back, it was stated by the Honorable Supreme Court. When you cannot waive the fundamental rights, then fundamental rights should be safeguarded by the nation through the judicial forums, that is constitutional courts under 226 or 32 is concerned. And insofar as the Indian Constitution, since its adoption in 1950, as a dynamic and ever-evolving document, it reflects the spirit of time while also providing flexibility to adapt the changing social, political, and economic realities. Insofar as the flexibility ensures that constitutional ethos remains relevant. There is flexibility is there. We are not saying that we were the Supreme Court has not taken all the powers given to the Parliament to amend. But they said, while amending the provisions of the Constitution, don't interfere with the bricks on which the entire fabric has been made. That was the outcome of insofar as the Keshwananda Bharati. Insofar 368 of the Indian Constitution has been perpetual state of judicial scrutiny by the Honorable Supreme Court from Shankari Prasad to Kohelo recently in 2007, which includes the Keshwananda Bharati. The Honorable Supreme Court in cases preceding to Keshwananda Bharati empowers the Parliament to effect any amendment to the Constitution at will. Although the theory of basic structure first used in Keshwananda Bharati, but it was expounded by the German thinker, insofar one of the judgments in Germany is called as Dieter Conrad, a very great political thinker. He said, because one thing we know, the way in which the law student will read the Constitution is different from a political science student reading the very same Constitution. Because we read the Indian Constitution through the interpretation of the judgments. The way in which the political thinkers will look into the societal aspects. So that's why there will be dichotomy. Even in India, maybe perhaps that was one of the reasons the political thinkers say that Keshwananda Bharati judgment requires review. But we, the law fraternity people, we say that everything already fixed. Don't touch it. If you touch the Keshwananda Bharati, is nothing touching the sun itself. If you touch the sun, you will ruin. Not possible at all. That's what insofar as this aspect, if you look at the judgment of the Nambiar and German thinker, his judgment it was followed. Apart from this, two learned judges of the Honorable Supreme Court in Sajjan Singh, where the 17th Amendment was challenged, Justice Mudalkar and Justice Hidayatullah's judgment. In that case, insofar as the 17th Amendment was challenged, if you read the judgment of Hidayatullah and the Mudalkar, they are the one who said, they said there are certain aspects, it is already embodied in the Indian Constitution. They did not say basic feature. They said, those ethos you cannot change. It has to be continued. Our Constitution is a living document. It is not a static. It does not require anything insofar as denting all these aspects. These are all the judgments where we can find the judgments rendered by Hidayatullah and Mudalkar in Sajjan Singh. If I would say, what was conceived in the mind of the judges in Sajjan Singh took birth in Keshwananda Bharati. Therefore, these are all because the aspects where the birth of concept of basic structure we can see. Insofar as the other aspects, dear friend, the concept of basic structure, of course, nowhere stated in the Indian Constitution. Need not be. Because we followed many things in convention. Everything we cannot vote to the constitutional provisions. Take for an example, as soon as the general election is over, the majority leader of will be invited by the governor or the president to form a government. But where do you find a provision in the Indian Constitution? There is no provision. But the executive head, that is either president or the prime minister, the governor, he inviting the majority in which the party has secured vote. He will be appointed as he will be invited to form the government. But there is no provision in the Indian Constitution because we have followed the conventions also. If our Constitution, though it is written and followed the conventions, follow the convention of basic structure theory also. Equally, it is also important to look into this. And insofar as the doctrine of the basic structure say that Parliament can amend all the provisions of the Constitution except basic structure. That's why the Article 362 but it ensures that the integrity and essential values of the Constitutions are preserved, while still allowing the certain amendments to accommodate changing societal needs. The power is given to the Parliament to see to it that you can make amendment. What is societal needs are required, but not change the essential aspects. And the specific exponents of the principles that make a basic structure of the Indian Constitution not explicitly stated. But in the Keshavananda Bharati case, just if you see the A.K. Sikri, that's one of the important aspects. Justice A.K. Sikri was the first jurist who has been elevated to the Supreme Court. Perhaps that is one of the mind where the conservative mind has gone and a flexible mind was opened in the minds of Justice A.K. Sikri because he's the first jurist appointed to the bench directly from the jurist to the Honorable Supreme Court. But if you look at the Justice A.K.'s judgment, he said there are a number of parliamentary democracy, sovereignty, many federalism, many things that he has stated, but they did not say, even all the 13 judges, they did not say how to locate a particular thing is a basic structure. That's only through an experience in the society. That's what insofar as those aspects is concerned. The basics, instead the judgment left room for future interpretation and consideration. In Keshavananda Bharati case, Supreme Court just laid down, there are certain things you cannot change. It gave some 3 to 4, if you're Jagban or any judgment if you see. But even if you read the dissenting opinion by the judge in Keshavananda Bharati, Justice Khanna's judgment, even he says that there are certain aspects, don't touch it, though it is a dissenting opinion. But these are all the things where we can say that, but don't amend the core values of the Constitution without checks and balances. Because our Constitution is not mere Constitution, dear friends, where the constitutionalism is embodied in the Constitution itself. If such be the case, we need to have some discipline. What type of discipline? Constitutional discipline, not political discipline. If you want to maintain a constitutional discipline, then in the wings of the government, it is not the will of the people, but it is the will of the Constitution prevail. That's what we have seen after Sabarimala and this RGBT case and many cases where constitutional morality will prevail insofar as not the will of the people is concerned. Maybe take for an example, in a democratic principle, the will of the people, but don't think it's a 51% majority. 51% is not a criteria for distributive justice as Aristotle stated in his norms as such. The Constitution must prevail in this society. A greater legal significance has been power to amend the Indian Constitution. So, Indian Constitution is a remarkable document that has provided a bedrock of our democratic and pluralistic society for over 7 decades. However, it is imperative to understand that a Constitution, like any living entity, must evolve to keep pace with changing needs and aspirations of the dynamic nation. And insofar as this aspect is concerned, let there be a balance between the stability of the Constitution and change in the society. The Constitution, in the absence of democratic values and adherence to the rule of law, it is only a legal facade, because we cannot live without rule of law principles or the democratic principles. The Constitution gets metamorphosed into constitutional law only when independent constitutional courts safeguard the fundamental rights by exercising judicial review. Judicial review, what we have seen, I think Marbury in Madison case, Justice Holmes himself has expounded in that case. But what exists under Article 368? See, we say that Constitution can amend the Constitution, but don't touch the core values as such. Take for an example, certain aspects. Nowadays, I think after this technology has been adopted and globalization in economic criteria, one is adaptation to contemporary issues. The world is not the same as it was in 1950, we are aware. But when the Constitution, that was when the Constitution was adopted, we face new challenges such as cyber security, environmental issues, emerging technologies, and the amendment allows us to address. Parliament can make law to protect cyber security, environmental issues, emerging technologies. You can make law. We won't say anything that power is vested as a constituent power under Article 368. Secondly, insofar as protecting, expanding fundamental rights. See, our Constitution enshrines, because when our Constitution was, the fundamental rights were being guaranteed. But even thereafter, Article 21A was incorporated, providing right to education at basic level. You can do all these things. It is, and Article 16, Class 4 was added, 16.5, 15.4. Many articles even you have incorporated even after 1950. When such a power is given to you to see to the cyber security, environmental issues, emerging technologies, or to do certain things as per the social, to improve the social justice, because it's a touchstone to the Indian Constitution. These are all the aspects you can do it. And even so far as the economic reforms is concerned, because after 1996 globalization, many economic reforms have been made, amendments have been, statutes have been, the statutes have been enacted by the parliament. There is no impediment for that. But the only thing is, don't touch the core values. And so for securing national interest, see, India's security and sovereignty face evolving threats. Amendment allows us to adapt our constitution to meet these challenges. You can make any law related to maritime, air, any space law, the number of legislations are there. Those are all the aspects where we cannot touch all these things. Even in so far as federalism and state autonomy, the 2 levels of the government and 7th schedule is there, where the entries have to be made, list 1, list 2, list 3. Doctrine of occupied field has been made in Article 254. These are all the area in which you can make a law, but don't touch the core values as such. Promotion of inclusivity. India is a diverse nation, and our nation must reflect its diversity. And amendment can help in promoting inclusivity, whether by recognizing the rights of linguistic or religious minorities, or by ensuring representation of women in the legislature. You can make law. 33%, why 33, 50 you can make, but don't touch the core values as such. And nextly, insofar as the technology advancement, in the age of information technology, the Constitution should also evolve. Amendments can address issues like digital privacy, data protection, and cyber security to protect the rights of the citizens in the digital world, for which always the power is vested with the list 1 of the schedule, provides for empower the central government, empower the parliament to make law on these aspects. Insofar as environmental conservation is concerned, given the growing concern about the climate change and environmental degradation, amending the Constitution to include stronger. Anyway, Article 51A is there. Article 1939 is concerned, certain amendments have been made. They are all nothing post 1950. You can make law relating to these aspects, but don't touch democratic principles, secularism, justice, rule of law principles. These are all the bedrock of our Indian Constitution as such. The ability to amend the Indian Constitution at 360 is not just a legal provision. See, 368 is not a mere legal provision, but it is a democratic necessity to ensure that the Constitution remains as a living document that can adapt to the needs of the rapidly changing society while preserving its core values. Amendments must be made with utmost care and responsibility. So these are all the area you can do it insofar as the aspect is concerned. Insofar as the other aspect is concerned, due to paucity of time, sorry, just 8 pages out of 31 I'm there. So I would say that there are certain aspects where this Sajjan Singh case, very aspect relating to 17th Amendment, Golaknath case was there. Golaknath case where, please read the judgment rendered by the K. Subrao, where he formulated the 3 aspects. One is textual interpretation. Because all of us know you're known for dissenting opinions, but rendered his judgment is an eye-opener for us. Firstly, he say that textual interpretation. Justice Subrao examined the language under Article 13, Class 2 of the Indian Constitution and concluded that it unequivocally prohibits the Parliament from making laws that abridge or took away the fundamental rights. He concluded that fundamental rights were an integral part of the Constitution, and any amendment that affects these rights would be unconstitutional, which affects the fundamental rights. To promote the fundamental rights, you can make amendment, but don't affect it, don't abridge those fundamental rights is concerned. Nextly, the doctrine of basic structure, as I told, and insofar as the constitutional supremacy. The majority opinion upheld the principle of constitutional supremacy both in I.C. Golaknath as well as in Keshavananda Bharati. and it could be altered or violated by Parliament through amendments that affected fundamental rights. That cannot be done. And insofar as the parliamentary sovereignty is concerned, see, dear friends, we have governed insofar as the constitutional provisions are concerned. If the power is given to the Parliament to dent our core values, these aspects, then entire our fabric of the parliamentary system of government will change into the parliamentary system of government what is there in the UK. Because UK Parliament can make any law. Parliament is a supreme. But in India, Parliament is not a supreme. Constitution is the supreme. If you empower this power is given to the Parliament to make law, even to amend the core values, then there is no constitution at all. Then supremacy of the Parliament will be there. If at all, if there is supremacy of constitution, as in UK said, they can do any law except change man into woman and woman into man. That's what the UK constitution. Here also it will be there. Don't touch that, all those things. Insofar as the parliamentary sovereignty is concerned, that's why the Article 368, where the word power was removed and procedure was incorporated through amendment, vis-a-vis the 13th clause 2 of the Indian Constitution. And insofar as the safeguarding the fundamental rights and judicial activity. See, one of insofar as the Justice Khanna's judgment in dissenting, insofar as the Keshavananda Bharati is concerned, if you give more judicial scrutiny about the amendment to be made by amendment of the Constitution by the Parliament, then there will be a judicial activism is there. That's what one of the things probably was there in the mind of Justice Khanna, who led the dissenting. But it is not like that. This Supreme Court is a guardian of fundamental rights. 32 itself is in the article, in the part 3 of the Indian Constitution. When you say that the Parliament, the Supreme Court itself is a final interpreter of the Constitution, then safeguarding the fundamental rights lies with the Supreme Court. When such being the case, you cannot say that there is excessive judicial activism. We can see number D.K. Basu, then the A.K. Chopra case, many MC Mata cases, how many cases in which Lakshmikant Pandey case, many judgments where we can see, we cannot say it's a judicial activism. What the courts has looked into to implement or to advance what is needs for the society is concerned in the absence of the law. To fill the gaps, to fill the interstices in the law, the Supreme Court has held many concepts like this. When such in the case, we cannot say that we cannot accept that part of the judgment rendered by Khanna, though maybe a dissenting, of course, in Keshavananda Bharati is concerned. And if you look at the two aspects is concerned, see, always basic is permanent. Circumstantial requires change. Basic thing don't change, and in circumstantial is concerned, that can be changed is concerned. Just I will, if you look at the many aspects is concerned insofar as the Keshavananda Bharati case is concerned, what will happen? Take for an example, let us think, instead of the Supreme Court in Keshavananda Bharati case evolving this concept, if it is negative in what will happen? We have already seen the post Keshavananda Bharati, 3 judges have been superseded because they are in the majority. Justice K. Segde, Sheelat and Grover, if I remember it. Those 3 judges were superseded, and Justice Indresh was made as a Chief Justice. You can see the emergency was imposed. That is a post Keshavananda Bharati case. Despite we are having the 13 judgments, executive did under the so-and-so aegis of so-and-so, interfere with all these things. If there is no Keshavananda Bharati case, I think probably today is not India, something else. Because the executive always prevail over because we know everything, absolute power, absolutely. When such being the case, if the power is given to the executive to do everything, executive or parliament, whatever may be the thing, they can efface everything. One day even the humanity also. Those things we cannot give room for all these things. And insofar as the aspect is relating to the Keshavananda Bharati is concerned, adopt certain changes there. and insofar as the conceptual breakthrough has been made in the Supreme Court, even thereafter it was reiterated in subsequent the Minerva Milk case, or insofar as the Maneka Gandhi case is concerned, and S.R. Bommai, where made the way, and Coelho reiterates the principle of a basic structure. And if we evaluate all these things, we can arrive at a conclusion that the should not be any tinkering these core values. That's not necessitated. See, when I am happy with a system, why I have to invite certain things which affect me? When we are happy, 140 crore people, every day we get 2 meals. Nobody can say that. Everyone now in India, 140 crores people get 2 meals. Only because of checks and balances in the government. Checks and balances, acts expounded by the Supreme Court in many cases. Separation of power, even Article 40 of the Indian Constitution, made where 3 wings of the government are functioning. But after all these things, what was the need to tinkering this aspect is concerned? Just I will come to my conclusion part, where the doctrine of basic structure emerging from the crucible of constitutional debates represent not merely the legal principle, but a profound assertion about the nature and sanctity of our constitution. It embodies the understanding that constitution must be adaptable to the evolving needs of the society. There exist certain foundational principles, that is the basic structure, that are immutable and beyond the reach of arbitrary alteration by the parliament. The Keshavananda Bharati case heard by Supreme Court was a watershed moment that marked a decisive shift in the interpretation of amending power of the parliament is concerned. Because Chief Justice Sekhri introduced the doctrine of basic structure and essential features as a one of the central tenets of the doctrine in its recognition that the Constitution is not a static document. They did not say it is a living document, it's a dynamic document. It imports all type of amendment, but not amending the core values is concerned. The basic structure doctrine has become a touchstone for evaluating the constitutionality of amendments and laws. And it is essential to recognize that judiciary, through various judgments over the years, has continued to refine and expand the contours of the basic structure. This adaptability ensures that doctrine remains a relevant and robust tool for protecting core principles of the Indian Constitution. Moreover, this doctrine serves as a guardian against potential abuses of power. By stipulating the certain features of the Indian Constitution or beyond the reach of the amendments, the judiciary acts as a check and balance on the powers of the legislature. It prevents arbitrary or capricious changes to the constitutional framework, ensuring the preservation of the foundational ideals that the framers have evolved. In conclusion, the doctrine of basic structure represents a trump of constitutionalism over arbitrary amending power to be exercised by the parliament. The Keshavananda Bharati case and the doctrine it introduced remind us that our constitution is not a mere parchment, but a living testament to the values we hold dear. The enduring legacy of the basic structure doctrine lies in its capacity to act as a beacon guiding us through the complexities of governance. It stands as a guardian, ensuring that spirit of justice, liberty, equality, and fraternity endures for generations to come. The doctrine serves as a testament to the resilience of Indian democracy and the commitment to constitutional principles. I would say that let us celebrate it as a landmark judgment that fortified the foundation of our democracy. One has to read the judgment of Keshavananda Bharati case as a footnote to the preamble to the Constitution. As we know, preamble is a key to open the minds of the Constitution. If such be the case, Keshavananda Bharati is a footnote to the preamble. That's what I would say. Preamble is a footnote to the Constitution. Keshavananda Bharati judgment is a footnote to the preamble itself. If such be the case, if you change Keshavananda Bharati, change the Constitution itself. That's all, nothing I would say insofar as aspect is concerned. And it is better to keep the constitutional safe. It is better to keep the Constitution safe in the hands of we the people of India. And such preservation was made and saved in Keshavananda Bharati case through enunciation of, we know what happened to 3 judges of the Supreme Court later, and executive power ruins the democratic principles. 39th and 42nd amendments introduced a flagrant violation of constitutional values. Eventually, the same was invalidated in Indira Gandhi and Minerva Mills. And like preamble is a key to so and so. And in the lastly, just I will quote the recent the foreword by Justice S. Ravindra Bhatt, former judge of the Supreme Court. He opined in his foreword to the theory of basic structure, savior of constitution and democracy, that it is the basic structure is to protect the enduring values against the push and pull of electoral politics, demands and promises, and that the doctrine of basic structure was emerged as an essential safeguard, one that continues to serve the vital purpose of the constitutionalism, regardless of ideological and political majority. This thing, dear friends, I conclude. I shall be very grateful to the institution for having invited me and share my few thoughts as a student of law. And I would say there should not be any discussion further about the basic structure, because don't tinker it. If you tinker it, you will change Bible. If you tinker it, you change the Quran. If you tinker it, you will change the Bhagavad Gita. These are all the things. If you don't touch all these things, you cannot change all this. Bible, Quran, or Bhagavad Gita, you cannot change. Likewise, our constitution. Likewise, our Keshavananda Bharathi. Thank you, one and all.
Thank you so much, sir. We are highly grateful to you, sir. It was a knowledge-packed speech with brevity and precision, outlining the basic structure, doctrine, and the clarion call that Keshavananda Bharati's decision is a footnote to understanding the preamble of the Constitution, which we consider as key to the Constitution of India. And it was a wonderful oration with regard to the whole ideas, the whole values and the philosophy underpinning the Constitution of India, and that too through navigating through the pertinent case laws. Thank you so much, sir. I call upon Mr. Ali Farhan, Assistant Professor of Manipal Law School, to introduce Professor Srikrishna Deva Rao, Vice Chancellor, NALSAR University of Law.
Honorable Justice E.S. Indresh, Swamiji Sachidananda Bharati ji, Honorable Pro Vice Chancellor Madhu Veeraraghavan ji, Professor Avinash Dadhich, our Director, the ladies and gentlemen, students, a very good afternoon to all of you. It's a pleasure and privilege for me to be introducing Professor Srikrishna Deva Rao and to be hosting this program. I can't say that I'm so much happy having you all here in this auditorium in MIT. Please give a big round of applause for yourself. So, before giving an official introduction of Professor Srikrishna Deva Rao, I would just like to give a small personal introduction of Srikrishna Deva Rao. So when I see him, two lines come in my mind. Simplicity is the ultimate sophistication. Sir is so simple, I can't say. Yesterday I met him for the first time, but it was like I am meeting a guardian. So he's so simple. Sir, I am really thankful to you for being so down to earth, so simple. So Bengaluru, he told me that Bengaluru is second home for him, as he from 1990 to 1998 he has taught in LSIU Bangalore. Then he went to other places. He originally hails from Hyderabad. So we can say that Hyderabad is his Janbhumi and Bengaluru is his Kambhumi. And now a bit of official introduction. I couldn't resist myself before giving his personal introduction. So Professor Srikrishna Deva Rao is a teacher and scholar in criminal law and access to justice. Professor Rao is currently Vice Chancellor NALSAR University of Law, Hyderabad, which is one of the best university of law in India. Before joining NALSAR, he was the Vice Chancellor of National Law University, Delhi for 2 years, and he also served as the Vice Chancellor of National Law University, Odisha for 6 years. Professor Rao was a Fulbright Nehru alumni. He had the distinction of working with 5 prestigious national law universities in India for the past 3 decades. Can you imagine? National Law School, Bangalore, NALSAR, Hyderabad, Gujarat National Law University, Gandhinagar, National Law University, Delhi, and NLU, Odisha. His major areas of research are in criminal law, and Criminal Justice Administration, where he has contributed to significant research in preventing custodial deaths. The Supreme Court of India borrowed his ideas in the landmark D.K. Basu case in the year 1997. The Land Rights Paralegal Program of Andhra Pradesh State was an offshoot of his course on legal aid and public interest litigation at NALSAR, Hyderabad in the year 2003. He developed a specialized diploma in paralegal practice at Indira Gandhi National Open University in 2009, where he was the founding dean of the Law Department. He was a visiting fellow at the University of Washington, Seattle in 2012, and School of Oriental and African Studies, SOS, London in 2013. Professor Rao is chairman of the Committee for Reforms in Criminal Laws, constituted by the Ministry of Home Affairs, Government of India in 2020. He was a member of the National Services Legal Authority, NALSA, in 2018 to design the curriculum for 4 mandatory clinical courses. He is currently the member of Delhi State Legal Services Authority. Professor Rao received the highest award in the field of criminology, Kumarappa Reckless Award, for his outstanding contribution in criminal justice education in India by the Indian Society of Criminology, ISC Chennai, in February 2020. Professor Rao was a part of the Indian delegation to present the Universal Periodic Report, UPR, of Government of India at the UNHCR Council at Geneva in November 2022 last year. Sir, we are very privileged and honored to have you here. Sir, please may I invite you to come here and share your few words. Please, sir.
Yes. Yes. Sorry, sir. Please. Because I have a court work. Yes. Shri Sachidananda Swamiji, Justice Indresh, he has to attend to the court. Avinash, friends, you have discussed over last more than 2 hours several silent features of the Keshavananda Bharathi judgment. As a law students, lawyers, judges, not only in India, several parts of the world, read Keshavananda Bharathi as an important new interpretational text of the Constitution. Justice Indresh mentioned about the interpretation tools and techniques. Before Keshavananda Bharathi, the Indian Supreme Court from 1950 to 1973 used to look at, whenever they have to interpret a constitution, look at the text of the constitution. Of course, it's important. That's what all lawyers will look at. They will look at where is the CRPC. Is there any provision in the IPC CRPC? But 73 was a departure, Keshavananda Bharathi. Why the departure? Again, credit goes to Justice Hansraj Khanna. 7 judges, 6 judges. I don't think in future ever Indian Supreme Court will meet more than 6 months. Hundreds of pages, several opinions. Nani Palkiwala, Sirvai, Nirande, Attorney General at that time. Amazing. Why it is different? 1973. And Khanna has to be given the credit, H.R. Khanna. Well, H.R. Khanna said, we have to look at not just merely text of the Constitution, that is called as a positivist interpretation. He said, let's go to the structuralist interpretation. That's an American method of interpreting the Constitution. Where he derived? He derived from the principles. The Justice Indresh said There was a German professor, look at. The German professor has written, 1965, he visited India. He addressed University Law School, Banaras and perhaps in Chennai. Then he wrote this article. This article, Justice Khanna's source, not the Indian Constitution or the Constituent Assembly debates. I think we should first remember that as students of law. Textualism, constitutional text, there's a limitation. That's called as a positivist interpretation. But Justice Khanna has the first time visualized structuralist interpretation, moving beyond the text to principles, spirits and values. That's where he said, there is something basic feature. That's he called as a basic structure doctrine, basic features of the Constitution. And Justice Khanna, as I said, he guided the majority. There was a discussion, debate, and of course, we should also remember during that time the political context of 1973, 1971, 72, 73 in India. You know what is the political context? Indira Gandhi won with a massive mandate in 5th general elections in 1971 with 350 out of 520 seats. The Indira Gandhi government enacted the 24th constitutional amendment to overturn the Golaknath. This is another tragedy in the Indian constitutional history. Whenever the court says something, instead of listening or implementing, the parliament used to bring a constitutional amendment. That was the problem. So that's where this political, if you look at that political context, so Golaknath, the Indira Gandhi government, because it's a majority. In fact, political sciences several times they have said, whenever the parliament is in majority, it will bulldoze the Supreme Court. Supreme Court will assert when the parliament is weak. This is not to go back to Rajni Kothari or any other political scientist. That's the truth we have seen. So the Indira Gandhi 24th constitutional amendment to overturn Golaknath by stating that the power of the parliament to amend the constitution is unrestricted. That was after the Golaknath. But in these circumstances, Kerala Land Reforms Act 1961 was included in the 9th schedule of the constitution. That's where Swami Keshavananda Bharathi emerges, and he was advised by the Manipal Kewala, one of the brightest lawyer India ever had. So that's the law was challenged. So the Supreme Court, particularly, I would quote and how this Khanna has brought the major interpretation in this case. Significant portion of Khanna's judgment was based on foreign and comparative law. He relied on the article, as I said, published by the German scholar Konrad, as I said already, who visited in 1965. So that was the major, where the Supreme Court struck down a small portion of the 26th Amendment on the basis of basic structure doctrine. I also wanted to take you again to Justice Khanna. Now let's come to 1973. Okay, first time the Supreme Court said, you amend anything. So Parliament was also happy because they are saying you amend anything, but don't amend basic features which is called as the basic structure doctrine. I will not go into detail. Now let's come to the 1975 emergency. ADM Jabalpur judgment. ADM Jabalpur was a Shivkant Shukla. Again, you look at Justice Khanna's dissenting opinion. If you read Justice Khanna's dissenting opinion, it flows from Keshavananda Bharathi, his majority judgment of 1973. I think that is an importance of Justice Khanna, who said, the only judge who dissented was the Justice Khanna. And in fact, it seems, he said, He told his sister, Justice Khanna told his sister that the judgment I am delivering today will cost me my Supreme Court appointment, and so it was. He was never made as the Chief Justice of India. I was wondering, in fact, like me, several people are also were looking at, when in 1973, in the Keshavananda Bharathi, Supreme Court was so emphatic and propounded a new constitutional interpretation, constitutional judicial review we call, or new constitutional interpretation. Why did not do in 1976 in Shivakant Shukla, or popularly or infamous we call as the habeas corpus case? Why? Is it a fear of emergency? Because entire, no, not just fundamental rights, the right to move, the High Court was also suspended. The lone dissent voice was H.R. Khanna. Let me just take here few moments to look at H.R. Khanna and how recently people said, and if you look at the constitutional history, 5 times habeas corpus is buried. But before I look at 5 times burial of the habeas corpus, let me look at what in the ADM Jabalpur, 28th April 1976, Justice Khanna has said. Justice Khanna, like Keshavananda Bharathi, he looked beyond the text and words of the Constitution. He looked at the purpose of the Constitution. He quoted American statesman and jurist again, Chief Justice Charles Evans Hughes, and he said, "Dissent is an appeal to the brooding spirit of the law, to the intelligence of the future day when a later decision may possibly correct the error into which the dissenting judge believes the court have been betrayed." And now we have seen 5 times burial of habeas corpus judgment. What are these? First, 44th Constitutional Amendment to Article 359 prohibiting suspension of Article 20 and Article 21 during the emergency. That's where the 44th Amendment, we know Janata Party came into power and then 44th Amendment was passed. That's the first burial of the Shivakant Shukla or habeas corpus case. Second burial happened in 2007. Supreme Court said this amendment had impliedly overruled by the habeas corpus case. That was a judgment of 2007 Supreme Court. Third burial, Justice Venkatachalaya said, while delivering Justice Khanna's memorial lecture in 2009, that the majority judgment belonged to the dustbin of judicial history. Fourth burial of habeas corpus case is the 2 judges bench of Supreme Court. In 19th November 2010 decision said habeas corpus case was wrongly decided and majority decision violated fundamental rights of large number of people in the country. Last burial of habeas corpus case happened in 2017 in the Puttaswamy case, 24th August 2017, 9 judges bench of the Supreme Court expressly and finally, formally overruled ADM Jabalpur. But I would, this visualized by H.R. Khanna, but that H.R. Khanna's habeas corpus perspective we could see in the Keshavananda Bharathi case. The Shivakant Shukla habeas corpus case decisions was attributed to the fear psychosis created by the emergency. Basic structure doctrine, which had few takers in 1973, acquired greater legitimacy, you could see, after the emergency. And now you see the 5 burials is because of the basic structure doctrine, but that at that time, the 4 judges of the Supreme Court did not have a courage and craft to withstand at that time in 1976. So, as I said, few takers for the basic structure doctrine in 1973 now has acquired a greater legitimacy because this constitution has basic structure remained. New interpretation of the basic structure started coming up when in the Keshavananda Bharathi in 1973, the basic features of the constitution was raised, but later on we could see it was extended even also to the legislative thing. There comes the Maneka Gandhi case of 1977. Another landmark case of Maneka Gandhi where They have said, this is the issue in Maneka Gandhi also. People were looking at, can the basic structure doctrine be used, judicial review of an ordinary legislation? That was answered in the Maneka Gandhi case. The Supreme Court held in that case that it would not be procedure established by law in under Article 21 unless it was fair and reasonable law. The post-Maneka Gandhi constitutional interpretation was symbolized by the width of liberal interpretation of the basic structure doctrine, especially in the fundamental rights and the recognition of many unenumerated rights. I'll stop here. Just last continuation of what in the Justice Bopanna's lecture also, in his article, he said in the concluding para, he said constitutional endurance. Basic structure doctrine is a constitutional endurance, continuity of the constitution. It will remain. Keshavananda Bharathi is an immortal, and Keshavananda Bharathi basic structure doctrine is also immortal. Over the years, the basic structure doctrine has allowed Indian judges to adopt innovative strategies in initiating the public interest litigation, creating continuing mandamus. And Justice Bopanna could not come. Justice Bopanna, along with Justice N.V. Ramana and one more judge, for the first time has stopped the implementation of the sedition. Where did they derive the power? Even now, the government of India, now with the new criminal law amendments, both the Indian Penal Code, Criminal Procedure Code and Indian Evidence Act, maybe what happens we have to see, but that was the Justice Bopanna also one of the signatory to that Supreme Court judgment when I think Ramana was the Chief Justice of India. So over the years, basic structure doctrine has allowed Indian judges to adopt innovative strategies. We know about public interest litigation, how it has changed. Post-emergency Indian Supreme Court has become so powerful, assertive, because of the basic structure doctrine. And we could see that. In fact, you also know as a law student, there is a principle called as a continuing mandamus. Justice Indresh mentioned about D.K. Basu case. D.K. Basu case judgment was delivered in 1996, 97. But still it continues. Continuing mandamus. Several environmental law cases we see continuing mandamus. So this is a continuing mandamus is a power the judiciary has explored through these, because one of these freedom and dignity of the individual is one of the basic features of the Constitution said in 1973 in Keshavananda Bharathi. So I'll conclude that basic structure doctrine through the Keshavananda Bharathi provided legitimacy to the Supreme Court. Even though these arguments were raised in 1950 in A.K. Gopalan case, but at that time the Chief Justice of India, Chief Justice Kania said, no, we will confine only to the text of the Constitution. Now we have seen after 73, this basic structure doctrine evolved the judicial activism, public interest litigation, and this provided public legitimacy to the Supreme Court. After all, the Supreme Court derives legitimacy from people. In the words of Justice Krishna here, he calls them as a little Indians, Daridra Narayanas. And otherwise, people will look at court as an elitist institution. For them, Keshavananda is the fight between court and parliament on the right to property, and the mock fight between elitist court and a majoritarian legislature. Of course, Keshavananda Bharathi case is different. It's a temple's property, not a general right to property of jamindars or jagirdars. That distinction we have to keep in mind. The court has become strong, identified with the poor and powerless people because of the Keshavananda Bharathi. This charge brought judicial activism of post-emergency period. That means liberal interpretation of Article 21, Article 14, Article 19, and reconceptualization of basic rules of judicial process. Consciously or unconsciously, that created ever evolving the Constitution that is called as constitutional endurance, constitutional continuity, Constitution as a living and a dynamic document. This through this Keshavananda Bharathi, Supreme Court moved closer to the people. Thank you for giving this opportunity to meet and interact with you.
Thank you so much, Professor, for the enlightening words. It is always said, life of law is not logic but experience, and that is how Keshavananda Bharati decision comes up as innovative and highly relevant and contemporary in the present circumstance. Now I invite Advocate Vasant Krishna, Legal Counsel, Manipal Group, to render the vote of thanks. Please, sir.
Good afternoon to all. Honorable dignitaries on the dais, all the invitees, respected Pro-Chancellor, Deputy Registrar, Dean and faculties, and principals from various institutions, and my dear students. It is with immense pleasure and profound sense of gratitude that I stand before all of you today to extend my heartfelt thanks on behalf of MAHE for gracing today's lecture program on constitutional ethos in the light of Keshavananda Bharati's case as part of the Constitutional Law Lecture Series. First of all, I would like to thank Honorable Justice A.S. Bopanna ji for sharing his detailed speech. Due to last-minute unavoidable issues, he could not join us. Thank you, sir, for sharing your valuable speech and enlightening us on the Keshavananda Bharati's matter and the Constitution. On behalf of entire team of MAHE, I would like to thank Honorable Justice E.S. Indiresh, Judge, High Court of Karnataka, Bengaluru, for delivering the special address. Thank you, sir. My Sashtanga Pranamas to His Highness Shri Sachidananda Bharathi Swamiji, Pontiff of Shri Edneer for all the blessings poured on us. Thank you. I extend my warm gratitude from the bottom of my heart to Professor Dr. Srikrishna Deva, Honorable Vice Chancellor of NALSAR University of Law, Hyderabad, for joining us in this program and enlightening us with his special address. Thank you, sir. Ours is an institution of 2 years. We need your blessings always to grow to the level of your height, sir, and your institution's height. Thank you, sir. I am also obligated to thank all the guests present here for their participation and support in making this event as successful. I would like to thank our charismatic Pro-Vice Chancellor, Professor Madhu Veeraraghavan, for all the guidance and support. Thank you very much, sir. I also thank Deputy Registrar, MAHE, Dr. Raghavendra Prabhu, Director, Professor Avinash, and faculties of law, all the supporting staff, my dear students, and all those students, those who have joined from various places. You are all gathered here to uphold the Constitution. Thank you very much. I wish my all the best to all the students for their future and to build their life at a later date. Thank you. I thank to the IT team and today's program conductor MC and all the supporting staff in this regard. Satyameva Jayate, Vande Mataram. Thank you.
Thank you, sir, for the elaborate vote of thanks. And this is also for your information that around 500 online participants are there right now witnessing this event, and that's a huge participation from the online participants. Thank you so much, and I appreciate and acknowledge their presence, the online presence. Thank you so much for joining us. Now we have a special request to Professor Srikrishna Deva Rao, sir, to give away the certificates of participation to few faculties who have joined us. May I call out the names, sir? Dr. Sendil Kumar, Sri Balaji College of Law, Bengaluru. Dr. Jyoti KM, Bishop Cotton College, Women's Law College from Bangalore. Srimati MS Vani, ALC College, Bengaluru. Mr. Mahesh Sharma, SBRR Mahajanas Law College, Mysuru. They have traveled a whole lot in the morning to reach here to join us on this occasion. Srimati Manjushri, Vidya Vikas Institute of Law, Mysuru. Mr. Pramod, PES Law College, Mandya. Mr. Gangadhar, Vidyavardhaka Law College, Mysuru.
You can call a student and give them so Ramanavar Law College, Banerghatta.
Mrs. Karthika, Dr. B.R. Ambedkar College of Law. Please come. Srimati Shahnaz, Sharda Vilas Law College, Mysuru. Miss Vindhya K.N. Nagegowda Law College. I would like to invite few students from Ram Manohar Lohia College present over here to take over the certificate of participation. Thank you so much for being with us. Ram Manohar Lohia Law College. Yeah, he's coming.
Okay. Done.
Thank you so much for all the wonderful audience, and always keep hoping for the best and shining with the rekindled ideas of enlightenment. Thank you so much for your participation. Let's all rise for the national anthem. Sushant? There is a small announcement. All the students, please collect your certificates of participation with the registration counter outside there, and then please proceed for the lunch.